Please, my lord. Lordship, item number 48 to 52, Lordship. Giving item 48 to 52. Yes. 48 to 52. Lordship, may it be listed after. I think the parties there conveniently. There was 18. 18. Yes.
List on 18/3/2024 as paid for by Satya and the government rate.
Lordship, I also beg to mention item number 9. Affidavit in opposition is under preparation, Lordship. So can you grant me 2 weeks' time, Lordship?
You have taken consent of the other side.
I cannot locate the other parties this month.
Just wait for some time then. We'll prepare.
I'm waiting for the petitions.
What size are represented?
Yes. 2 weeks.
On the prayer made by Learned just after 2 weeks, so as to enable him to file affidavit in opposition in the matter of language.
May I please, your lordship. Lordship, here I am for private respondent number 4, in which lordship we are yet to file a Bakalatama. So my gun is 3 weeks time, lordship.
Make it within 2 weeks. This is the whole matter. You just add his name for the private respondent, also place for. Both players, the state government and the private respondent.
Judicial lordship. I beg to mention item number 44.
The main counsel is in bereavement, so I plea 2 weeks time maybe when. Hearing item 44, item number 44.
Council holding the date for the petitioner is in bereavement. Accordingly, matter stands adjourned today. Based after 2 weeks.
Obliged.
Lordship, I beg to mention hearing item 20. If it can kindly be listed after 3 weeks, Lordship, I have only recently handed over the file, so I need some time.
You've taken consent of the other side. You've taken consent of the other side.
Yes, Lordship.
Okay.
I am for the petitioner.
No.
Yes, Lordship.
There's a press number 2. You have taken consent.
Yes.
Okay. With consent of the other side. The done counsel for the petitioner place for adjournment. Prayer is allowed. List after 3 weeks.
To be
Item
obliged.
20.
Yes, 20. Lordship, I have similar prayer for hearing item 42.
Okay. You're making prayer after consent?
Yes, Lordship.
Okay. Same order in 42.
To be obliged.
Yes, Your Lordship. I beg to mention item number 47. Your Lordship, this matter has been wrongly listed.
Why wrongly listed?
Your Lordship, it was supposed to be fixed for 18th of March.
The last order, that was fixed for 50 March.
Okay.
Already.
Okay. Both sides are represented. List on 18 March. 2024.
Your Lordship, I would also like to mention item number 21 to 41.
Why bunch matters are being adjourned?
Your Lordship, my senior is out of station. So if the matter could kindly be fixed after 3 weeks.
It's a old matter. 2020 matters are also there.
Yes, Your Lordship.
You see, if the council is absent and this is a bunch matter, number one, you should have given a adjournment slip earlier so that the court knows about the adjournment, number one. Number two is that because of these bunch cases, other matters for the lawyers who want to do the matters, their cases are not listed. And the name of your lawyer is not there in the absence list. Then how should we accept it? There should be some criteria. The bar must deliberate and tell us. You see, 2 days in a row, Monday and Tuesday, my boat fell. I had to rise at before 12. Have I come from the principal seat only for the purpose of adjournment and allowing the boat to fall? You don't want to do matters, you tell us in advance. We'll not list your matters. Why get the matters listed and then take an adjournment and then let the boat fall? Because I would be unemployed in half an hour.
Lordship, then the matter can be fixed on Monday.
No. Listing of your matters only, there's no other matters in the registry. There are matters. So why should your matters be only listed? Inform us.
Your Lordship, my senior is out of
when you-
station for.
No, it's okay. We are not asking your senior, we are not arresting him and keeping him here. You should have given his name in the absence list. Why it is there? Why the practice is there? You could have told us, you should have a courtesy of telling us in advance. Because you see, the number of adjournments taken. I have not come here just to give adjournment and then sit idle. It's very difficult to sit idle. From 12 o'clock to 4:30, sitting here idle. After adjournment. So I should, the first thing in the morning is that I should adjourn the entire matter. All the list adjourned. Why should I do even one case? That's not the way. We will not adjourn it. you change the practice. You allow your names of your counsel who's not absent, who's absent, to be recorded in the absence list. We can't permit you just to say that the absence and then once matters are listed, off listed. Not that. 1 or 2 matters we understand. But 10, 20, 15 matters to adjourn in a single prayer. You permit that.
Your Lordship, my sincere apologies.
Next time, don't do it because this is the practice I will not appreciate.
Yes, Your Lordship.
Lordship, I pray the matter may be listed on 18, Lordship.
No, not 18th. It goes after 2 weeks. I'm not serious matters.
11th.
It goes after 4 weeks.
No, Your Lordship, Monday.
It goes after 4 weeks. We have no urgency in the matter. Let other matters be listed for the lawyers who want to do it. Is there interim order operating?
Yes, Your Lordship.
Then we'll vacate those interim orders.
Your Lordship, kindly grant us one last time.
Next time, don't take a risk.
Yes, Your Lordship.
You pray for an adjournment unnecessarily without lawyers' names being listed in the this absence list. We'll vacate the interim orders. List on 18/3/2024 as prayed for by learned counsel for the petitioner.
May I please, Lordship?
That's it. We just recorded. I just recorded. The court puts on record its displeasure on the prayer for adjournment, as the name of the lawyer is not mentioned in the leave note. We record our displeasure because this is not this practice. We don't like it. Yes.
Lordship, I beg to mention item number 11, Lordship.
Why?
Lordship, we have sent the affidavit for waiting, Your Lordship. So kindly grant us 2 weeks time to file, Lordship. I'm appealing for respondent number 1.
Just so much is something there. Okay, one last opposition of 2 weeks is granted to the respondent number 1 to file affidavit in opposition to the matter, filling which the matter would be heard on the basis of materials available on the record.
Lordship, our name has been wrongly reflected in the column of the petitioner's counsel, Your Lordship.
The SC shall reflect the name of learned counsel for the respondent number 1, whose Vakaratama is on record in the column for the respondents advocates instead of the names being reflected in the column for petitioner's advocate, because this we're listing the matter next.
Obliged.
That's all. Lots of effective mission item 5.
Item,
Item number 5. I
Right.
prepared the entire affidavit and
I have to obtain the signature. So let this little bit come up next week. Straight away.
How much time do you need? How much
I have,
time?
Prepared the contract. And I
No,
have
that
to
is okay.
update.
How much time? You tell us the date. There's a calendar in front of you. When you will file it? There's a calendar in front of you. Please tell us the date when you are filing it. Give us a date when you are filing it. Give us a fixed date when
Maybe
you are filing it.
after a week. Yeah, well.
Give a date. On 14th. Okay. The learned CCC prays for time till 14th. Now undertakes to file affidavit in opposition by 14th March 2024. In this case, notice of motion was issued by order dated 21/11/2022. Hence, it is made clear that if affidavit in opposition is not filed within the time allowed, the said affidavit in opposition shall not be made a part of record, and the matter would be heard on the basis of materials available on record.
Yes, Lordship. Lordship, I'd like to mention hearing item number 43, Lordship, on behalf of Amy, Lordship. This matter can come up after 1 week. 42.
Why you are taking adjournment in 22 matter? Why you are seeking adjournment?
Lordship, the standing counsel is in disposed, Lordship. The standing counsel is in disposed.
You see, this is something we will not accept unless you get it recorded in the leave absence raise this leave note. We'll hear the lawyer and we'll pass orders. We may not need the assistance of government advocate. It is refused. Unless you get their name reflected in the absence note, we are not entertaining those prayers. We can't allow the vote to fall. Just wait when they renew the prayer when the matter is reached. Let us see.
Lordship.
For motion. My pleasure, Lordship. I have to mention item number 13, Your Lordship. I'm making a mention on behalf of my senior Mr. Yamawati, CGC, Your Lordship. Here the union is yet to receive instructions, Your Lordship. So I pray that this matter may come out after 3 weeks, Your Lordship.
That's not 13. behalf of the learned CGC, prayer for adjournment is made. In view of the nature of grievance expressed in this writ petition, the learned CGC shall send a downloaded copy of this order to the respondent authorities so as to ensure that the affidavit in opposition is positively filed at least 2 days prior to the next date of listing. This Tom, how much time you are seeking?
3 weeks, Your Worship.
List on 1/4/2024. Send a downloaded copy of this order to the respondents. Correct. No adjournment in this matter.
Much pleasure.
For motion from the supplementary cost list, item number 53.
We'll issue a notice this matter. Okay, there was some query. Yes.
As per this provision, I'd like to place office memorandum, Lordship. This correction of this date of birth and death, it is permitted. Lordship. Paragraph is paragraph 4, Lordship. Roman 2.
No, not this. The query to you was whether the name can be changed.
Your Lordship, with that regard, I did not have any concrete instructions, but with regard to the inclusion and change of nominee, there is one OM issued by the government, Your
No,
Lordship.
this is not a case of change of nominee.
It is, uh,
This is not a case of change of nominee.
Yes, your
It's a case
substitution.
of substitution.
Yes, Your Lordship.
There was name of X earlier, and now they say the name is changed to Y.
Yes, Your Lordship.
So this is a change, substitution of the names. Is
And
that permissible?
Your
Because you
Lordship.
see, the doubt is created because of the use of language.
Yes, Your Lordship.
Now you see, in this petition, you are using a language that so-and-so retired from service, the petitioner's wife so-and-so is entered in the PPO and other records, the petitioner being the legitimate husband. So you see, why the question of legitimate husband comes. Husband is a husband. If there's a legitimate, then there's a presumption there is an illegitimate husband also.
Lordship, Lordship.
Correct.
I agree with you, Lordship.
Now, you are using a word and you see, name is total substitution.
Lordship, Lordship.
Instead of B Akala, now the name you want to write is Banger Mary.
Yeah, there is some,
Is that permissible?
yes.
And this PPO is being altered. After retirement, 2009, she retired. We are in 23. So during her service career, she did not know the name of the husband. When the PPO was, she got notice of retirement, she does not know the name of the husband. And after 15 years of retirement, now the husband comes and says that you please change the name of the nominee. Is that permissible? I'm just asking that question.
Lordship, Lordship. As per this office memorandum, this if the
It says the request for change of date of birth or age.
yes, Lordship, and then my brain is also it is one of the part of it.
No, but substitution is something you have to tell us.
Yes. and then for this change of this date, and then I have to
No,
produce.
that means
this,
you are trying to substitute a person. It's a total different man who is now coming in existence.
Yes, Your
Lordship,
Age, how can you say, how can an age change after passage of 14 years?
Lordship, here in this case, only this B and PE has to be checked, because as per the Aadhaar card, my name is indicated by still P, whereas in the BPO it is B. So there is not much difference, and then the person indicates the same person. And then as per this office memorandum, I have declared the affidavit in non-judicial step, as well as in the Aadhaar card, my name has been clearly indicated.
Okay, issue notice on this, in this petition, filed in Article 226 of the Constitution of India, whereby the petitioner is praying for substitution of his name and correction of the age of birth. The government advocate accepts notice
Which on behalf of 1, 2, 5, 6, and 7.
1, 2, 5, 6, and 7.
Yes, Your Lordship.
And who's, precision 7? The petitioner shall take steps within 2 days for service of notice on the respondent numbers 3 and 4 by registered post with ED. Notice is made returnable on, give date after 4 weeks. So. List on so. Take your document.
For motion, item number 54.
Will you issue notice here also?
Yes, Your Lordship.
Issue notice on this, in this declaration, filed under Article 226 of the Constitution of India, seeking direction of the respondent authorities for regularization of the service of the petitioner. Petitioners, yes, sir. Multiple petitioners. The learned committee advocate accepts notice on behalf of the respondents. Requisite extra copies of the writ petition be served on in course of the day. List after 4 weeks.
Much obliged.
In the earlier case also, for the government advocate, please write the extra copies. The government.
For admission, item number 1.
Yes.
It is Lordship. Lordship, the pleadings are completed in this case, Lordship.
Argue the matter.
Lordship.
Lordship, before the petitioner start his submission, I'll just like to make one small submission here. By an order dated 1/2/2024,
Yes.
the petitioner has submitted that he will be filing his affidavit in reply during the course of the day. And if affidavit is filed, Your Lordship, I have not received a copy of that. If it is not filed, Your Lordship, I have got nothing to say, Your Lordship. I can proceed with the.
There is an affidavit on record 13 February.
So if it is filed, I have not received a copy of the affidavit in reply, Your Lordship, till date.
Lordship, I have already filed, and when the
No,
affidavit was filed,
you
my
see,
learned friend was not in the premises.
There is no acknowledgement here. Without acknowledgement, if you file, we'll not take cognizance of this. We'll proceed with the hearing.
Lordship.
You did not give for a purpose.
I have extra copy, Lordship.
No.
Lordship.
You have it.
Lordship.
Keep it stored because there are many things we keep in our lock and key.
Lordship, my learned friend was not in the premises.
Many
Lordship.
things we have.
Lordship, thereafter also, that too, today
apologies,
is,
Lordship.
your Lordship, today is the
No, but you see, if you have not served, it is with a purpose.
Lordship.
We'll permit you to fulfill that purpose.
Lordship, we-
If he does not know it, he will not respond to it and we will not hear it.
Lordship, this matter can be taken up tomorrow in this case, Lordship.
No, no, every day we can't take up your matters. Bar will be angry. That only one advocate's matters are being listed daily. But if you have not served, you have not served.
Lordship, my apologies. My apologies.
No, no, it's not a question of apology. You see, you have done wonderful thing. You have saved 5 rupees of photocopies. How many people get that opportunity? Does everyone get it? No,
No.
you are a privileged class. So enjoy that privilege. Why you want to surrender your privileges? Do it in course of the day.
Lordship, Lordship, if I may be allowed.
Correct. It's almost nothing here.
Lordship. If he is not relying, your Lordship, I'm ready.
Is relying or non-relying is irrelevant with the contents. But okay, list after 2 weeks. In the meantime, the counsel for the petitioner shall serve a copy of the affidavit filed on 13/2/2024 to the learned government advocate in course of the day.
Lordship.
For admission, item number 2.
Please, Your Lordship. The petitioners are the employees of the Nagaland Consumer Commission, my lord. Your Lordship, according to the Bagla Committee report of 2000, even the states like Sikkim, which has lesser number of cases than Nagaland, they have created 18 posts, Lordship. As far as Nagaland is concerned, till date, not even a single post is created. And the employees who have been serving in the department, most of them have served more than 10 years, Lordship. So, Lordship, we are asking for a creation of post as well as for regularization, Lordship, which is another issue is also, my lord, may kindly appreciate that. Although it's in the pleadings, I overlooked the prayer portion, Lordship, about the parity of pay scale. At least minimum pay scale should be given to the employees. We are still on fixed pay, Lordship.
No, you see, issues of pay scale must first go to the pay anomaly committee. The High Court in exercise of 226 will not say who will get what salary. That is beyond our competence.
But yes, Your Lordship, as my lord has rightly observed, at least the first thing that has to be done is the post creation, which is yet to be done.
Okay, yes, what is your stand, madam?
My stand is that the Bagla committee does not talks about regularization, it talks about sanction for Your Lordship for sanction of post, Your Lordship. Mandamus cannot be issued in that, Your Lordship.
First come, first, Lordship, at least the post should be created.
And they were all part-time employees, Your Lordship, and some of them, paragraph 7 and 8, Your Lordship. Or Your Lordship, 10 and 11. 2 of them were appointed on co-terminus basis, Your Lordship. That means the appointment will cease to exist as and when the president, Your Lordship, retires, Your Lordship.
Okay, so how do you expect the office to run if you don't have sanctioned posts?
Lordship.
How do you expect, how does the government expect a forum like
Your Lordship, yes, but it's a policy decision, Your Lordship. For that, we have to create sanction posts, and that this involves policy matters, and Your Lordship knows that mandamus cannot be issued, Your Lordship.
Where is the staff pattern in your affidavit?
Sorry, Your Lordship.
In your affidavit, have you disclosed what is the staff pattern in the Consumer Protection Forum?
Your Lordship.
In your affidavit, have you disclosed the staff pattern in your office, this state consumer?
Nothing has been
Staff
disclosed,
pattern.
Lordship.
No, Your Lordship.
No. So therefore, we don't have a permanent court master, we don't have a permanent peon, we don't have a permanent driver
All
for
are
the.
on fixed pay basis, Your Lordship. All are part-time employees, Your Lordship.
Lordship, the entire affidavit of the state is shirking responsibilities. The issue not coming to the main point, Lordship. Post-creation, Lordship, is a must.
No, please.
My lord.
Either you complete your part or you allow her to speak.
My lord.
If you want to continue, please complete your part and then let her
Lordship,
make a
my
submission.
lord.
Anything you have left out, please complete your part of argument. Please complete whatever you want to say.
So, Your Lordship, post-creation, Lordship, my submission is very simple as I've already submitted, my lord. The post-creation, Lordship, the question of whether mandamus lies or not, that issue is not there, Lordship. It is a must that post should be created for the commission to run, my lord.
That is a legal issue.
Yes, Lordship.
We have to, when a question is raised by the government
My lord.
about the power of the court to grant mandamus,
Lordship.
we'll have to tackle that issue.
My lord.
And on that, what do you have to say? How do you assert that the court has the power to issue mandamus for
My lordship,
creation of posts?
A commission is already set up. The chairman, which my lord is fully aware that is a retired High Court judge, running without a permanent employees, lordship, without any post-creation, lordship. And the employees, many of them have served for more than 10 years, lordship. The commission has also written several letters to the state government, and the state has been sitting over it in the last more than 15 years, my lord. So, lordship, the only option left is for seeking the.
You have a copy of this State Commission Act?
No, lordship, I have not annexed that.
You have a copy of that?
I have only annexed the Bagla committee report, my lord. According to the Bagla committee report, the structure and how the Consumer Commission is to function is in the Bagla committee report, my lord.
Who has constituted this committee? How was this committee constituted?
The Bagla committee report. What should may kindly come to page 23, the annexure 10. This is sanctioned by the central government for the commission. May I take lordship to page 29.
Just a minute. The state government has a rules for the functioning of this commission. Does the state government have a rule for functioning of this commission?
There must be, Your Lordship. Lordship, but even in the Consumer Protection Act, Your Lordship, this will also cover, and then
now, which is the act you are following? It is the 2019 new act, or you are still following the 2008, this 1986 act? Which is the act which is being followed? Try to get this Consumer Protection Act. There are two acts. One is 1986. One is 2019.
I take your lordship to page 29 regarding the state consumer dispute redressal commissions.
Yes.
This is regarding the State Consumer Dispute Redressal Commission, and page 30 is the staff constitution and how it is to be constituted, your lordship, page 30.
No, we can't, we won't understand. The reason is, we are telling you the reason. You see, Consumer Protection Act 1986 was repealed. And it was substituted by Consumer Protection Act 2019. And in 2019 Act, the provision of section 107 repeals 1986 Act. Therefore, this committee report, when I'm asking you this question, is based on the fact that this, I have not seen this report, but this report was dated when? This report is dated, this was prepared when?
This is in 2000, your lordship.
2000. So in
Yes, Lordship.
2000, you see in 2000 when it is proceeding, you are showing us page 29.
My lord.
In 29, they are relying on the provision of section 16 of the Consumer Protection Act. And in 16 of the Consumer Protection Act 2019,
My lord.
they said is a provision for power of the district collector.
Even the Act of 2019 also, lordship, it's in the section 16, composition of the state commission.
No, 16 is Consumer Protection Act, power of the district collector.
Oh, this is 1986.
Huh.
Where's the Act of 2019?
So therefore, you see a committee who does not even know the existence of a new act is giving us a report. If you have to place reliance on it, we should also understand that they are aware of what they are doing.
In that case, my lord, I can go back and go through the 2019, the provisions of the act, the sections, and then.
No, provisions we are aware. Don't worry about that.
My lord.
Now, how many, as per this report, how many members are there in this state commission? How many members are functioning? This commission has how many, has a president and how many members?
As of now,
Yes,
president and 2 members, lordship.
2 members.
Yes, lordship.
You still have doubt on the power of the court for issuing a mandamus?
Your Lordship, sorry?
Do you still have doubt on the power of the court to issue a mandamus? We'll show you. You see, under the new act of 2019, you can note down the provision. It is section 42 which prescribes that there shall be a president and B. There is 42(2)(b). It says not less than 4 or not more than such number of members as may be prescribed in consultation with the central government. So if it is 2 members, do you still have doubt that the court has limited powers to issue a mandamus?
Your Lordship, those two members are already there, Your Lordship.
It's okay.
But with regard to the officers and staff, Your Lordship.
No, you see, we will just give an example.
Yes, Your
We'll
Lordship.
change the, what you call, the parameters, and then you will understand. Is there a fun in having a post of advocate general in the state if there's no appointment? Is there any logic in having a establishment of a senior government advocate in the court without any government advocates? Is there any logic in having running a criminal court without a public prosecutor or additional public prosecutor appointed? Pick and choose basis also they can do ad hoc. We'll have ad hoc advocate general, ad hoc government advocate, ad hoc public prosecutors, and then run the show. Can the court run like that? You set up a court, you don't give me a court master, you don't give me a stenographer, and you expect the courts to function.
Your Lordship,
And
but
you're-
it all depends on the policy of the.
Oh, we'll
court.
direct
And Your
them.
Lordship-
Don't worry, we'll direct them.
Your Lordship, and also in my paragraph 13, Your Lordship, we're saying that, if I may be allowed to read, Your Lordship, page 5, Your Lordship.
Page 5.
Yes, Lordship.
Yes.
I'll just read from the
But
beginning. Your Lordship.
but you'll have to tell us everything. Don't go by these reports. You have instructions and tell us how many people are there working, how many posts are there. Are those details available here? I don't think so in your petition.
Lordship, all the employees are petitioners in this case, my lord.
No, you should, we first must know about the setup of the commission. How many officers are there? How many people they are working with?
The officers and staffs all together, there are only 7 of them, Lordship.
Only 7 of them. What
Yes,
are their
Lordship.
posts?
My lord, all the designations are, in fact, the appointment orders are also annexed with the writ petition.
Just tell us, instead of us reading that, all those things, just tell us how many officers are there, or staff is there.
Lordship, may kindly come to page 14, annexure 1. This is the petitioner number 1's appointment. Was appointed by the order dated 30th August 2011 as LDA computer assistant. The Lordship on fixed pay of 6,000 rupees. Presently, he is also functioning as the acting registrar because there are no other officers appointed in the commission, my lord.
Just right. Heard Mr. Joshua Seki, legal counsel for the petitioner, as well as
In the Holy Your Lordship.
Government advocate,
Yes, Your Lordship.
appearing for the respondents. Next para. It appears, it is noted that you got this act. Enter the act. 29th. Okay, thank you. It is not that. An act of parliament. Consumer Protection Act, 2019 was enacted. Which was published in the Gazette of India Extraordinary on 9/8/2019. And the and ex- and various provisions of the said act came into force on 27/2020 and 24 July 2020. Full stop. By virtue of the provision of section 107 of the Consumer Protection Act, 2019, the Consumer Protection Act, 1986 was repealed. Full stop. Next para. As per the provisions of section 42 of the Consumer Protection Act, 2019, it is prescribed that the state government shall, by notification, establish a state consumer dispute redressal commission, to be known as the state commission, in the state. Under subsection 3 of section 42 of the said act, it is prescribed that the state commission shall consist of, within bracket A, president, semicolon, then and, within bracket B, small b, not less than 4 or not more than such number of members as may be prescribed in consultation with the central government. Full stop. Under the provisions of section 46 of the Consumer Protection Act, 2019, instead of that, you say section 46 of the Consumer Protection Act 2019 is quoted below. Full stop. Next, on a query of the court, the learned counsel for the petitioner has submitted that, as per his instructions, the state commission is presently functioning with a president and 2 members. First off, it is submitted that there are 7 staff who are all temporarily appointed and no post has been created exclusively for the functioning of the state consumer commission in the state of Nagaland. Full stop. At this juncture, the learned government advocate has submitted that the creation of posts and appointment of officers and staff in the state commission falls within the exclusive domain of an executive function. And it was submitted that the court would not have power to issue a mandamus for creation of posts or for directing the state government to appoint staff in the state consumer commission.
As well as regularization, Your Lordship. They're seeking for regularization.
Regularization I have not stated right now.
Lordship.
Unless there is a post, there can't be a regularization. So
Yes,
this is not something we are saying. Next para. Yes.
Your Lordship, is this for disposal?
Hmm? No, I am not disposing of.
Okay, then. Otherwise, Your
This will
Lordship,
be a continuous mandamus. We will
Okay.
monitor it and we will ensure that the state government
My lord.
makes this functional.
Your Lordship, Your Lordship may also turn to 46 on Your Lordship of the Consumer Protection Act. Your Lordship.
That is already
We have quoted that.
recorded.
No, I'm in my submission. I'm also saying that it says that the state government shall determine the nature and categories of the officers. So
That's
that
why
means,
we are
Your
saying,
Lordship-
you let me finish the order,
Okay,
then you
Your
will understand. It will be a continuous mandamus.
Okay.
We will not wash our hands off with this writ petition
Yes, Your Lordship.
and we'll see that it functions.
Yes, Your Lordship.
Correct. Now you can only tell us by what time the court should make it functional. That liberty we give you. You can tell us 3 months, 6 months, 1 year. You give us a time limit by when we should make it functional. And we'll try to accept your request. No, it's not coming. Okay. Next paragraph. In view of the fact that as that if we accept the submission of the learned counsel for the petitioner, this is a case where the state government has failed to comply with the mandate of the Consumer Protection Act 2019, and for the best reasons best known to the government of the government of Nagaland, the state commission does not appear to be lawfully constituted in accordance with the provisions of section 42 of the Consumer Protection Act, 2019. It also appears that the state government does not have a will to.
Your Lordship, I'm sorry, I'm interrupting, but in my paragraph, we're saying that the state is considering the matter, but it's since.
No, you see, consideration will go on. There's no time limit. We have 100 years to think. We expect our life to be 100 years. Correct? So we have 100 years to think. So many good things to do. Government has no interest in this. That's why we are saying. It appears that government has no intention of making the state commission functional by appointing appropriate staff. Full stop. Staff to assist the state commission. Full stop. Next paragraph. As per the, what is this called, Mr. Jamir? This I forgot. This is called preface, or it is called what is this called? In the top of the act they write this purpose and intent, aims and purpose. It's aims and objects. Okay. As per the aims and objects of the Consumer Protection Act, 2019. The said act. It's a statement. Make it statement of objects and reasons. Correct. This Consumer Protection Act is to provide for protection of the interests of consumers and for the set purpose, to establish authorities for timely and effective administration and settlement of consumers disputes, and for matters connected therewith or incidental thereto. Full stop. with the said pious object, comma, if the state government does not appoint the, does not constitute the state commission in accordance with law and does not create posts for the effective functioning of the state consumer commission, comma, this would be a classic case where the state has failed to act in accordance with the act. Next para, therefore, comma, the court is inclined to issue notice on the state respondents to inform the court as to what steps they are contemplating for constitution of the state commission in accordance with the mandate of section 42 of the Consumer Protection Act, 2019, and what steps do they propose, does the government propose to create posts and to appoint staff in the state consumer, permanent staff in the state Consumer Protection Commission within the scope and ambit of section 46 of the Consumer Protection Act 2019. Full stop. Let this order be brought to the notice of the Chief Secretary to the Government of Nagaland. Full stop. Next para. No, within bracket, respond number 1. Full stop. The Chief Secretary to the Government of Nagaland shall file an affidavit after 4 weeks to apprise the court of the steps being taken by the state government for making the state consumer protection, state consumer commission
Yes, my lord.
functioning in accordance with law. Next para. This one, after 4 weeks, give a date. After 4 weeks, give date. 9. We give some more time. 15, okay. 15/4.
Lordship, it will be Nagaland State Consumer Dispute Redressal.
Just write the correct name. Just write the correct name. Nagaland
State Consumer Disputes Redressal Commission.
Okay. Presently is functioning from where?
Lordship, the office.
It has been functioning in different places, lordship. The office
No,
was
it
burned
can't.
down and it was functioning at the State Circuit House, just opposite to this court building, your lordship.
Or is it? And who is the chairman present?
The president,
President, who is he?
Justice retired Ukatosu.
Okay. Just add one more line there. Just put it appropriately in a place. The state shall also respond as to by what time a permanent office shall be set up for functioning of the Nagaland State Consumer Redressal Commission.
Nagaland State Consumer Disputes Redressal Commission.
Okay, correct. Make the correct name. Okay.
For admission.
Will
Item
oblige, your
number
lordship.
3.
Publish, your lordship. Lordship, I admit to fail the affidavit in reply in response to the opposition filed by the respondent 1 to 4. So I pray that 2 weeks may be granted.
Just a moment. Two weeks' time as prayed for is granted to the petitioner to file affidavit and reply in the matter.
Oblige, lordship.
For admission, item number 4.
Lordship, I'd like to mention on behalf of Tibapong, Lordship. On behalf of Tibapong, Lordship. If this matter can come up for 3 weeks, I'm here to file a counter, Lordship.
Just a moment. Where is the order of status report? Which order was passed for status report? Please button up your coat. Please button up your coat. Don't keep the breast open. What has to be buttoned up?
Thank you, sir.
Yes, where is the order of latest status? We can't permit that adjournment. This is a status report about what? This is, the court has called
Appointment.
for status report of what? The court has passed an order to call for the status report. Status report of what?
Actually, your lordship, they have a short time to file an affidavit. in
For
response.
what? No, this is not a time to wake up. You should wake up. You, madam, you should wake up at your home, study in your study, and then come. This is not the place to wake up. Correct?
Yes.
No, we adjourn the matter. List after 2 weeks, as the Durham counsel for the petitioner could not tell the court as to which status report of what was sought for by the court. No, be prepared. Every item must be prepared for hearing. Don't come casually.
For admission, item number 6.
Please, Your Lordship. Your Lordship, the affidavit is under preparation, so another 3 weeks may be granted, Your Lordship, for filing counter.
Yes, there is an entry. Yeah.
The matter relates to appointment on the basis of land ownership, Your Lordship.
Can you be specific? It is 3 weeks for preparation. Have you got instructions or not?
Yes, Your Lordship, it's under preparation, Your Lordship. I've got an
Correct.
instruction, Your Lordship.
Look at the calendar and tell us a date when you are filing it. And madam, you will also button up your coat. Madam, please button up your coat.
Yes, Your Lordship.
Please button up your coat. Please button up your coat.
Maybe, Your Lordship, 2nd April, because there is a holiday also, so 2nd April, Your Lordship.
So holidays you don't work.
No, Your Lordship. For filing, Your Lordship, maybe there might be some difficult, that's why, Your Lordship.
Correct.
Before the.
No, you tell us. Yesterday we had a matter.
Yes, Your Lordship.
At the end of the day, I think 4.05,
Yes, Your Lordship.
we completed the hearing.
Yes, Your Lordship.
Now, I had to retire because the time of the court was out. Correct.
Yes,
Now, by what time you expect that the order should be released? as a judge, when I'm functioning, I have to pass orders.
Yes, Your Lordship.
Today we have dictated few orders.
Yes, Your Lordship.
Now please tell me, by what time these orders should be released? Three days, 5 days, 2 weeks, 3 weeks? How much time should we need?
Your Lordship, as early
Should-
as possible.
Should
Your
I
Lordship.
need to release these orders? Because my secretary will transcribe it. She will also need some time for typing. I'll need some time for revising, for correcting errors. By what time you expect my orders to be released? If I passed orders today, you expect the orders to be out by day, correct? And somebody is asking for a prayer which is made in the writ petition, you are saying 3 weeks. And even in 3 weeks, you are calculating those holidays.
No, Your Lordship, the convenience of the court, Your Lordship. Your Lordship asked me a date, that's why, Your Lordship, I'm
No,
just giving a convenient date, Your Lordship.
But
Otherwise,
3 weeks-
subject to Your Lordship's convenience.
Always be reasonable when you are given so much of time for adjournments. We'll make it 2nd March, but make it sure that it happens. 2nd April.
Oh, Your Lordship, Your Lordship, by
Correct.
that time it will be.
The Learned Government Advocate undertakes to file affidavit in opposition by 2nd of April 2024. So it is made clear that if affidavit is not filed within the said time, comma, the affidavit in opposition of the state shall not be accepted on board without payment of cost of rupees 10,000 to the petitioner.
Lordship, there is an interim. May it also continue?
The petitioner. Full stop. Interim order passed earlier stands extended till the next date of listing. List on 5/4/2024.
Much obliged, Your Lordship.
For admission, item number 7.
Lordship, in this case, the state has already filed the affidavit, Lordship. On going through the affidavit, the state has raised the contention that I did not appear before the verification committee for regularization of my service, Lordship. If I may be allowed a week's time to file reply to that, Lord.
So okay. On the prayer and written counsel for the petitioner, 2 weeks time is granted to file affidavit in reply in the matter.
Lordship. Much less, Lordship.
For admission, item number 8.
May it please, my Lord.
Just a moment. Yes.
Yes, Lordship, here my challenge against the respondent number 4 and respondent number 5. The respondent number 4 was appointed in departmental promotion post, 100% departmental promotion post in 2005.
Yes.
Respondent number 5 was appointed after the petitioner in 2000.
You scored less marks. You were at serial number 7, but the petitioner was at serial number 4. The respondent was at serial number 4.
Lordship.
You are at serial number 7.
Yes, Lordship.
So how do you justify that the petitioner should be appointed?
Yes, I will come to that, Lordship. As per the service rule, Lordship, in 2006, at that particular-
you have a spare copy of this rules?
Yes,
You have a
Lordship.
spare copy of these rules?
6:15 and now recently service rule 2022. However, at that particular time, this was the, so my lord will kindly see that against the respondent number 4. At serial number schedule 2, Lordship.
Just a moment. Is it a limited departmental promotion examination?
Lordship.
Is it a limited departmental promotional examination? Okay.
Yes, Lordship.
Okay.
Now,
Just a moment. At the back benches, I find that you are students of law college. Correct.
We are the students from Kohima Law College.
From Kohima Law College. You are from which semester? Sixth semester.
Semesters.
Okay. And madam at the back, if you want to watch your mobile, you have to be out. Correct? You understand whom I am mentioning? If you want to watch your mobile, be outside. In the courtroom, don't watch your mobile. Please don't do it. Yes. Because you have been sent here to understand something. You are in sixth semester. You may not understand what is going on. But if you are attentive, you will learn the art of court practice. You'll only learn from the submissions of the lawyers, from the articulate manner in which they make their submissions, they address on the questions of law. And therefore, I would request all of you as a student to be watchful of the proceedings. You may not understand at the end of the day, but we don't expect you to understand, because even very seasoned lawyer, merely by sitting in the courtroom, may not understand, may not follow what is going on. But what we expect from you is that when you come to know that there is a provision of law being quoted, after going to your college, you look at that act or the provision of law and then try to understand the deliberation which went on in the courtroom. This is how you will learn. And this is how I have learned in profession. Correct? So there's no, what you call that, theory of Horlicks does not apply. That you are feeling weak, take a spoonful of Horlicks and then take it and you get energy. You don't get knowledge of law like that. You will acquire knowledge only when you follow good lawyers who are arguing in the matter, and you go back and do your homework and try to understand the law which they were trying to articulate and to present before the court. Correct? Everybody understood? Correct? Do I hear from you? You have understood what I'm trying to say? Yes. And let me give you a small advice. You see, I come from a background where I was a trial court lawyer. And I'm proud that I was a trial court lawyer. I'm proud of it. The reason is that when you are a trial court lawyer, you come to know about procedural law. Which part is missing when you are only doing writ petitions in the court? For a practical lawyer, procedural law is something you must know. Civil Procedure Code, the Criminal Procedure Code, now we have new act which has come in. It will come into effect from 1st of May. And then third is the Evidence Act. Because you find in your, not only in your would-be career to be a lawyer, but even when you have an inclination to understand what the legal practice is about, then also you will find that these practical laws, which are procedural laws, can only make you a good lawyer. So whenever you have spare time, you may not understand the text, but try to read these 3 procedural laws, CPC, CRPC, and Evidence Act. Yes, madam, sorry.
It's all right, Lordship.
Huh.
So obliged.
Yes, please
Yes,
proceed.
so 2006.
I
these
was
are-
asking a question whether it was a limited departmental examination for what you call in-service promotion.
Promotion in, sir. Yes, yes, Lordship.
It was an examination.
Departmental promotion,
Examination.
Lordship.
Okay.
So the respondent number 4, my lord will kindly see page 26, field number 24. The post of impositor. The petitioner was first appointed as inkman, Lordship, but that is okay. From the inkman till promotion to impositor, the cause of action arose from the post of impositor.
Page.
Page 26. 26.
Of the writ petition.
No, Lordship, service rule I have.
Oh, acha, service rules. Yes.
The original page is 26.
Yes.
Here I have used in other cases also, so it is being shown as 39, Lordship. So my lord will kindly see the shade 24.
Yes.
Plus 24.
Yes.
If my lord has found it.
Yes.
Impositor, the post of impositor.
Yes.
This is 100% the departmental promotion post, 100%. At column 3, Lordship.
Yes.
Now, my lord, at the right side, my lord will kindly appreciate. He or she must be a substantive incumbent of the immediate lower grade for 5 years of continuous service in that grade. So, in violation of this, the respondent number 4 was appointed in the post of impositor in 2005. That is one. That's why I am before this honorable court that in 2005, when it was a substantive, must be a substantive incumbent of the immediate lower grade with 5 years of continuous service in that grade. This is a draft service rule, Lordship. However,
you're respondent number 4. Yes. Respondent number 4.
Yes. So my grievances against the respondent number 4 is that he entering service, Lordship.
But then there's a Supreme Court judgment, and we are also following it, that if 2005 appointment you are challenging now, it will be belated and it will not be entertained. It will be barred by limitation.
Lordship.
Although Limitation Act does not apply in writ petition, but there is a thumb rule that if you allow right over this to be perfected by passage of time, then it will be a belated challenge. We use the term, what is the term? I forgot. It's
Lordship, in 2007, they, all of us are now promoted, the superstitions, everything, and till 2007, we are at the same level. Now, thereafter, no step has been taken, and now the department, DPC is going to sit. So, after promotion to printer post, all the respondents, as well as the petitioner. Now, all of us are at printer post.
I remembered that. I was trying to say.
Lordship.
Vigilantibus, non et dormantibus. That is the legal maxim.
Lordship, I will just appraise my lord. Whatever be it, Lordship, I will just like to impress upon my lord my these things. I'm just trying to show this honorable court that he was appointed in 2005 in a direct departmental promotion post in 2005. That is just the sequence that I'm trying to impress upon my lord. Now, then, can we come to page. The respondent number 5 was appointed in 2000 after the petitioner. Here the Lordship, the service rule provides, in 2006, the service rule provides that service rules. My lord, will kindly come to Rule 9 of 2006. Nineteen, Lordship, I beg your pardon. Seniority is at Rule 19, page 14. Okay. Nineteen, Lordship. Okay, Lordship, I am looking at 2006. There is 2007 also, at the 2006.
This is 2007.
2000, anyway, 2007 is also same.
Okay, okay.
Six, seven, same, Lordship.
Yes, 19, seniority.
Seniority is, yes, 19. Seniority in a cadre shall normally be determined with reference to their date of joining. I am on this, Lordship. In that cadre, provided that seniority of the promotees shall be determined in order of preference given by the committee, which shall ordinarily be in accordance with the seniority in lower cadre. Seniority of persons appointed through limited departmental examination or direct recruitment shall be determined in accordance with their position in the merit list. If in a calendar year, recruitment is done partly by promotion and partly by limited departmental examination and partly by direct recruitment, the seniority inter se of these categories of officers will be in the order given below. Lordship, however, Rule 19A, seniority in cadre shall be normally be determined with reference to their date of joining in the cadre. So what I'm trying to impress upon my lordship is that the appointment of the petitioner is, my lord will kindly come to, the first appointment of the petitioner is.
You said 2000.
Annexure A, page 14. This is the first appointment. The petitioner was appointed on 5th October 1999. Here comes the first Rule 19, Clause 1. In superstition of this office order number so and so dated 9th October 99, Sri Detho O Zehol is temporarily appointed as inkman in the Directorate of Printing and Stationery, Nagaland, Kohima, in the scale of pay of so and so. PM plus special compensatory allowances at the rate of 15% of basic pay subject to a minimum of ₹125 and maximum of so and so, and all other allowances as are admissible in the state of Nagaland from time to time. From the date of his joining, the appointment is made on purely temporary basis and may be terminated anytime by giving 1 month's notice from either side. The appointment is made against the post vacated due to promotion of Sri Lanu Pongner Inkman. So the petitioner was first appointed on 5th October 1999. Type out copy is page 15. It's not that very clear, my lord. Page 14. Then after this, the first seniority of Inkman was issued. Page 16, annexure B, Lordship. These are the seniority list of Inkman as on 1/9/2000. The petitioner is shown at serial number 13. Then page 16 annexure B, Lordship. Petitioner is shown at serial number 13.
And in this list, page 16,
Yes, Lordship.
what is the seniority position of respondent number 4?
Respondent number 4 is not yet entered into service.
Is not in service.
Yes,
Okay.
Lordship. And even the respondent number 5 is not here, Lordship. Even the respondent number 5 did not figure here, Lordship. This is 13 September 2000. Then annexure B1, page 18 is also as on 9/2001. Seniority list of Inkman 18. Both the respondents are not here. Here also the petitioner is shown at serial number 13. Type of copy is at page 19, Lordship.
Yes.
Then Lordship will kindly come to page 20, B2. Here
Just
is
a moment. Just a moment.
20 B2.
Just a moment. Yes.
Page 20, B2, Lordship. This is also a list of Inkmen. That is 2004. This is 7th May 2004. 10/5/2004. Here also, both the respondents number 4 and 5 are not here.
This is, what is the date?
Below is 10/5/04.
No, it is June. In the top, it is something June. 1st June 2004.
Lordship, at the top, it has been corrected, Lordship. 1st June 04. But as per the bottom, it is shown as 10/5/04.
Correct, correct.
Whichever, Lordship, I just place it in my Lordship's buildings.
Correct, correct.
First line, there's only one tree, there's only-
This is also the seniority of Inkman as on 1304. Seniority list of Inkman as on
No, you are at
1304.
serial number 6 now.
Yes, Lordship. I have come up to serial number 6.
And R5,
Both of them are not here. Respondent number
no, R5 is there.
5.
Oh, no, it's not
No,
there. It's
no,
not there.
it's
No, not
it's
there, not there.
Yes, Lordship.
Not there. Yes.
Then 21, B3. The respondent, the petitioner is at serial number 2. Page 21, B3. This is also seniority list of Inkman as on 111.5 strictly according to serial number as given.
Yes.
The petitioner now stands at serial number 2, Lordship.
Yes.
Then thereafter, my lord will kindly come to page 22, annexure C. This is the promotion order of the petitioner. That is 8 August 2006. Lordship will kindly appreciate this 8 August 2006. I may be allowed to read out order. Sri Detho Zehol.
No, it's okay. You said it is promotion order. You don't have to read it.
Oh, Lordship. He was promoted to impositor, to the post of impositor, the one which I have reflected in the
Yes.
in the service rule. So this is his promotion order. Then thereafter, Lordship will kindly come to seniority list of impositor. This is where the problem started. This is 14th May 2007, 23, annexure D. Seniority list of impositor as on 31/12/2006, strictly according to serial as given below. 1. Now the respondent number 4, who was appointed in 2005, comes in above the petitioner at serial number 2.
Yes.
Who entered service in violation of the service rules. Now respondent number 4 is now placed at serial number 2, who was appointed in 100% departmental promotion post. He has to be a substantive post for 5 years, Lordship, but in violation of the service rule, he entered and now placed at serial number 2 above the petitioner. Then serial number 6, Sri Renathang Ovung, respondent number 5. He was appointed in 2000, subsequent to the petitioner. As per the service rule, date of joining has to be the seniority in the cadre. So the respondent number 5 is at serial number 6, placed above the petitioner, whereas the petitioner is placed at serial number 8. This much, Lordship. So this is the first on 14th May 2007 when this seniority list Yes, Lordship. So this is the first seniority list of impositor that was first published. And when this seniority list came out, the petitioner the respondent number 4 and respondent number 5 were placed above the petitioner. And he has gone down to serial number 8. Against this, my lord will kindly come to page 25 in extra E. This is dated 7707. On coming to know of it, I submitted this complaint letter. Handwriting is at page 25 and the type out copy is at page 25A, Lordship. To the Director, Printing and Stationery, Nagaland, Kohima, complaint against seniority list of impositor as on 31/12/06. Sir, I have the honor
No, you don't have to read it.
Lordship,
Just-
Lordship.
Told me you have taken note of that.
Yes, Lordship.
It's your representation against their position above you.
Yes, Lordship. In 2007. That's why after this, no further proceeding has taken place. After this, all the respondent as well as the petitioners, now we are awaiting for next promotion. So we are all in equal place. That's why I have approached this honorable court. Lordship will kindly come to page annexure F, page 7. For some time I was attached to advisor urban development. So this is just, I'm trying to refer to my lordship. That's all. Page annexure E1, page 26. But I was released in 14 August 2020. Annexure F is my promotion to printer. This is my last promotion, as well as the respondents as well. So this is my promotion that is 18th November 2010. From impositor, I was promoted to the post of printer. Next year F, page 7. The promotion date is 18th November 2010, Lordship. This is where they superseded the petitioner and ahead of the petitioner, and they were promoted ahead of the petitioner in printer post. And this is the crux of my case, Lordship. Now, after this, there was no
Yes.
Yes, Lordship. Thereafter comes the seniority list, Lordship. For some time there was a gap after this, and 16 January 2015, the first common seniority list. Next year, G, page 28. Seniority list of printer. As on 1/11/2014, strictly according to serial as given below. This is 2015. Lordship will kindly what has happened here is, unfortunately, the petitioner was promoted to the post of impositor on 8/8/06. But in order to place the petitioner below the respondents, the respondent government in the seniority list kept on showing the petitioner promotion to the post of impositor as 1/8/2007. Now, Lordship will kindly come to serial number 13 and 14 are the respondent number 4 and 5. So here it can be make out worksheet for respondent number 4, serial number 13. He was appointed as impositor. We don't have his appointment order, but the seniority list shows. He was appointed as impositor on 1/8/2005, serial number 13. Then again, to be promoted to the post of printer, a person has to be in a substantive post for 5 years under the schedule. But within 2005, within 2 years, very exclusive logic. Within 2 years, he was again promoted to the post of printer. Entered on 1/8/2005 as impositor in a departmental promotion post. Then again, within 2 years, he was promoted to the post of printer ahead of all the seniors. Until that, my lord, we kindly see second promotion is just blank because he was promoted to the post of printer on 18/12/2007. Then there is no second promotion in his column because immediately promoted. Then respondent number 5 at serial number 14. He was appointed on 1/6/2000 as form carrier, not as inkman. However, lordship, equivalent post to the promotional post of impositor, form carrier and inkman, they are equivalent posts that I admit before this honorable court. However, lordship, in matters of seniority, since he entered as form carrier on 1/6/2000, the petitioner was appointed in an equivalent post prior to him into 1999, lordship. So this is where
Just on equivalent means
equivalent post form carrier and inkman
they
in promotional channel.
are equivalent.
Equivalent, lordship. That's why this is where the respondent number 5 was appointed in 2000. Equivalent, so I was in 1999, he was in 2002. Then he was appointed, this is why they have been placed above me, that is, he was promoted ahead of me on 1/11/2005 as impositor.
Just
Lordship. Serial number 14. Respondent number 5. They were appointed after me, but they were given promotion in superstition of the petitioner. That's why I have been placed below them.
just take a small break and come back.
Lordship.
It's on time.
Almost. Service rule. Yang lebih pokok by that department to rule exams. Again, two others are above him. So challenge. No, it's just that the Seniority and challenge, they want to be at one stance level. That is up to you. Ada rules lain. Siya na promote siya by the time right your new way na ma bedo appointment dia ma mo siya issue it for you what it is your what you can mama no 2500 what you promotion don't just build so you can you know that's it. The point number is the challenge. Then I have challenged the seniority. I think printer. Again, need promotion challenge. Atau kalau dia kerana department ni, dia mana I sudah lagi. What did 2000? Also the celebrities. 6 years, 7 years, it's a drop. But it was used in other places. 9. Okay, it was Korean I became a just thinking more recently by Shiri. Then now 2022. But these are not our cases, right? I mean, I just ini lagi ya, jadi biasa. Amina, ini kok berada di mana? Dari telepon apply sebetulnya. Of course, but yeah, almost of course. Lordship. So, my lord, you kindly come to page 28, annexure G. This is 16 January 2015, issued on 16 January 2015. The first seniority list of printers as on 1/11/2014, according to serial as given below. So, serial number 13 and 14 are the respondent number 4 and 5. So I'm trying to impress my lordship that 2005 directly appointed as impositor and within 2 years promoted as printer, respondent number 4.
Yes.
Then respondent number 14, actually number 4 is the respondent number 5. He was appointed after the petitioner on 1/6/2000 as form carrier.
Yes.
So both of them are junior to the petitioner. That's why I'm referring to this. Now petitioner is at serial number 20. By now, petitioner has gone back to serial number 20. Page 29.
Yes.
20. Now the petitioner was promoted to the post of impositor on 8/8/2006. Now here they are showing the petitioner to place below others. They have shown me as on 1/8/2007 as impositor.
Yes.
Lordship, for clarity, my lord can just, to substantiate page 22, annexure C. The petitioner was appointed on 8, promoted to the post of impositor on 8/8/2006. The document is here as annexure C, his promotion. However, in the seniority list, my lord will see that he was shown as appointed on 1/8/2007. Contrary to his promotion order. This is one. In order to place below the respondents, page 29, my lord has seen 1/8/2007. Then annexure 13, they continued G1. This is 2nd August 2016. Here also, my lord will kindly see respondent number 4 and 5 are at serial number 5 and 7.
Yes.
Serial number 5 and serial number 7, 4 and 5 are at serial number 5 and serial number 7, whereas the petitioner is at serial number 12.
Yes.
And here also, my lord will kindly see date of first promotion. It is noted as 1/8/2007. Lordship, to make him junior. Then page 32 is 2017 seniority list. Page 32, seniority list 2017. I just want to show my lordship that they have been showing that I was promoted on 1/8/2007, apparent on the face of record. Petitioner is at serial number 12. Respondent number 5 is at serial number 5. Respondent number 7 is, respondent number 4 is at serial number 7. Above the petition. Petitioner is at serial number. Here also it is shown as 1/8/2007. Then 2018. The petitioner number 5 has gone up to serial number 4. Petitioner number 4 has gone up to serial number 6. Petitioner is at serial number 11. Here also, my lord will kindly see, they have shown as 1/8/2007. His promotional, first promotional promotion, serial number 11. My lord will kindly see second promotion is 4 of them were all appointed on 18/11/2010. 4 incumbents were promoted together 18/11/2010. Second promotion. Then comes 2019. I have gone up to serial number 9. Respondent number 4 and 5 has gone up to serial number 2 and serial number 4. Here also they have shown me as 1/8/2007, first promotion. Page 36. G4. G5 is also 2020 lottery, same. My date of first promotion is shown as 1/8/2007. It's serial number 9. Serial number remains the same. Then page 40H. I have challenged this, Lordship. This is the first promotion order of the respondent number 4 and 5 to the post of printer. This is 18 December 2007. This promotion was given to the respondent number 4 and 5 after I submitted my first complaint letter against their seniority list. I submitted the complaint letter on 7/7/07, Annexure E, page 25. I submitted my complaint letter against seniority list on 31/12/06, Lordship. My Lord will kindly appreciate that I have the cause of action. I have submitted complaint on 7/7/07. Even after this, against the seniority list 31/12/2006, but they did not address my grievances and they issued this on 18th December 2007, giving promotion to the following. I may be allowed to read out order. The following.
You're reading which page?
40.
40. Just on.
Annexure H. Prior to this, my complaint submission is at.
Yes, that we have taken note, page 25.
Lordship. My complaint letter is prior to their promotion, where I have stated that Gauhati, the respondent number 4 and 5, has superseded me. For clarity, my complaint letter is at page 25E.
Yes, yes.
I have submitted prior to their promotion, Lordship. So after I submitted in July, even then on 18 December 2007, they did not consider my case and they promoted the respondent number 4 and 5. The following impositor of the Directorate of Printing and Stationery, Nagaland, Kohima, are hereby promoted to the post of printers against the vacant post shown below in the scale of pay of rupees so and so plus all other allowances as admissible under rules from time to time in the state of Nagaland with immediate effect. Serial number 2 is the respondent number 5. Sri Renathang impositor, printer, vice so and so. 4. At serial number 4 is the respondent number 4. Sri Gauhati impositor, 2, promoted to printer. So they were again promoted ahead of me, Lordship, in 2007. So I was promoted in 2010. That's why they were shown above me, Lordship. That is my humble case. Against this, Lordship, you kindly see page 41. I submitted against the seniority list H1 41.
Yes.
With due respect, I would like to bring to your notice that my joining date is 5/10/1999 Inkman, whereas 2 of my colleagues, Sri Renathang Ogong and Sri Gauhati, joining date is 1/6/2000 form carrier and 1/8/2005 impositor, respectively, but has been placed above me in the seniority list of printer. Sri Rajunityo, appointed as peon in the year 2000, has been promoted to deputy foreman, who is also junior to me. Therefore, an early action in this regard shall be highly appreciated. This is the petitioner's. Then thereafter, after I submitted this, Lordship, my Lordship will appreciate that after I submitted this complaint letter, at least they rectified in 2021 seniority list. they rectified my date of first promotion as 8/8/2006, page 42. After this, I'm shown at serial number 9.
Yes.
Here they have rectified 2021, 8/8/2006. Serial number 9, Lordship, if my Lord has
Yes.
seen it. Then in 2022 also, they rectified it as 8/8/2006 correctly. 2022, page 44, I1. 2022 also they corrected 8/8/2006. My Lord has seen.
Yes.
So 2 years, 2021 and 22, they corrected. Then again, I submitted another complaint letter, 28/6/2022, against the maintenance of serial number of the seniority list of printers. Annexure J, page 46. Basing on the seniority list issued by the department dated 8 June 2022, I am writing this letter to bring to your notice that my juniors, Sri Renathang Ovong and Sri Akamwati, has superseded me in the serial number maintained in the seniority list of printer presented by the department. The former HOD did not take the date of service entry into account while promoting in the past. This superseding advantage given to some junior based on favoritism and not according to seniority has delayed my promotion in the past and will further continue to affect my promotion in the future. Therefore, it is my humble prayer to the present HOD to rectify the mistake committed in the past and bring justification in this present time based on service entry. Presently, my juniors and I are on the same level printer. Hence, in the next promotion, it will be justified enough if I am given priority to my juniors. There are also some seniors who are placed below in the seniority list, but they are least bothered and do not raise their voice regarding the non-maintenance of strict serial orders based on seniority. However, it is a matter of concern to me, and therefore, with the direction suggested in the circular provided by the department to entertain complaint within a specific period, I put forward my plea to kindly make a review of the seniority list according and push up my serial number above my juniors. It is hereby clear that the juniors have superseded multiple times without any specific reason or remark. So this is the petitioners. Then J1 is also some of the colleagues who were supporting me, Lordship, supporting letter. We, the non-diploma staff director of printing and stationery, do hereby request for rectification in serial order maintaining the seniority list of printer handed out by the department dated 28 June 2022. We collectively place our support towards the complaint letter raised by Sri Deitho Jahol against non-maintenance of serial number in the seniority list. Being the initiator of the rectification, we appeal that he should be put up in the first place among the seniors for the welfare of non-diploma in the future. So, Lordship, there are 5 who are placed above, 5 of them supporting. Then, Lordship, confirmation is at Annexure K, 19 April 2022 is the confirmation. DPC. I am at serial number 7. (124), all in one order, Lordship.
Yes.
Yes, after this, Lordship, again, the impugn order I have challenged before the Honorable Court is at Annexure L, page 52. Again, they went back to square one and showed my serial number at serial number 6. And again, they have shown me 1/8/2007 impositor, first promotion. In order to place
Which
me-
page? Which page?
52.
52.
Yes, I have challenged this, the latest. At the time when I filed the petition, this was the latest seniority list of printers lordship, as on 1/4/2023. So I have challenged this so that there should be rectification lordship, or to bring out another new seniority list, or whichever my lordship diligence I will leave up to my lordship. Serial number 6. Now, respondent number 5 has become serial number 1. Respondent number 4 has become serial number 2. And serial number 6 is the petitioner, where again they have placed me at 1/8/2007 again back to. And above me, there is one Opangten Jem Sangtam. His first promotion is on 5/9/2006. And I should be placed even above this, but they are doing this to deny me, because my promotion was on 1/8, it's 8/8/2007, but here again they are showing 1/8/2007. I don't know why they are taking always 1/8 lordship. So the person at serial number 5 is 5/9/2006. So if I happen to be on 8/8/2006, I will be above this person also, lordship. So there is such the infirmities here in this seniority list, and I'm challenging this. Along with this, just one, I will my affidavit in reply to the respondent government affidavit in opposition. I will just show one document before the Honorable Court. I'm winding up, lordship.
No, don't, because I have some questions for you to unwind you. My first question to you when you started,
lordship,
same question I'll repeat again.
Lordship.
On the issue of delay. That was the first question when you started.
Lordship.
I would repeat that question again. The reason is that you see there you have shown us so many seniority lists. Everywhere you accepted the position that you were below, and then you made a complaint on 7/7/2007, and then you remained idle. It was not challenged. So a complaint of 2007, you are agitating now by filing this writ petition of 2023. 16 years of delay from that. And then when you accept it and you allow the right of others to fructify into a seniority position. So why would the court interfere with your seniority position? But yes, when your date of, there is a mistake in the date of promotion.
Lordship.
That has to be rectified, but still your position can't be changed vis-a-vis the respondent numbers 4 and 5.
Lordship, for that
There
matter,
are-
I will leave it to your lordship's diligence. However, here, lordship, I have also referred that it may be long or there may be delay or such, but from the first instances itself, I have submitted my representation. That is also one aspect my lord will kindly acknowledge. I have submitted my first representation in 2000, as and when the seniority list, that was not as per the seniority. I have submitted my first representation on 7/7/2007. When I got to know that they were placed above me. That may be lordship recorded. As well as I have also placed the service rule where the service rule is very clear that seniority in the gather shall normally be determined with reference to their date of joining in the gather, provided that seniority of the promotees shall be determined in order of preference given by the committee, which shall ordinarily be in accordance with the seniority in the lower grade. That is what the service rule says, Lordship. Seniority in the lower grade. So from the first instances, they have superseded me, Lordship. That is one aspect. Another is that a person must be a substantive incumbent of the immediate lower grade with 5 years of continuous service in that grade. But all those have been violated. So whether Lordship, though I subscribe to whatever my Lordship has opined, I also place my case that from the first supersession itself, I have submitted representation, and thereafter when the common seniority list came out, I have submitted so many representations for rectification. Besides that, Lordship, there is also, this was annexed by the respondent government, Annexure 1. Page 6. Annexure 1.
Yes.
They are saying that this is a new document to me, and this has been annexed by the respondent government. Minus of the capability test for promotion to the post of printers held on 9th October 2007 and 14th November 2007 in the offset section. If they can use this and say that the respondents are legally appointed, then they showed this document. Why not me, Lordship? By 2007, when they were doing these things, I have already submitted my representation against the illegalities.
No, I'm not being able to follow you. You are showing
Yes.
us page 9 for what purpose?
Page 6, Lordship, affidavit in opposition.
Affidavit in opposition by respondent for 1, 2, and 3.
Affidavit in reply to the
Oh,
affidavit
reply.
in opposition to the respondent number 1 and 1,
Affidavit in reply.
and 3. Yes,
Okay.
Lordship. My affidavit in reply.
Okay.
This is the document of the respondents. They can
Page number 6.
6, Lordship. The last page. My Lord has seen.
Yes.
Minus of the capability test for promotion to the post of printers. Hereafter, no action has been taken. That's why I'm before this honorable court, Lordship. On 9th October 2007 and 14th November 2007 in the offset section, in pursuance of the calling letter number so and so dated 21st November 2007, the committee had been conducted the capability test among impositors to promote to the post of printers against vacancies. The committee conducted the capability test of operate offset machine and platen machine letterpress with papers, jogging, and as per secured mark of merit wise. Names are mentioned below. 1. Sri Rajunito, he has been promoted to the post of foreman now, he has gone. Then 2. Sri Renathang, 17.5 marks. C. Sri Si Pongshon, 11.5 marks, he has retired, Lordship, Sri number 3. 4. Akangwati, respondent number 4, he got 11.5. Then 5. Sri Marsazang, 11.5. 6. Sri Martin Nsendang, 11. 7 is the petitioner, Lordship. Sri Deito, 10.5. Then 8. Sri Ti Amongba, 10.5. Then 9. Sri Redulhole, Lordship, 10. Then 10. Sri Opang Temjen, 10. Sri Tems Nungsang.
No, that's okay. The names are not important.
So what I'm trying to impress my Lordship is, then if we go by this document, Lordship, the person actually number 3 and 5 in the final seniority list ought to be placed below me, because in the merit list I was above them. This is all, there are two aspects. One is from the service rules aspect where my name ought to have been
No,
placed.
I'm not being able to follow you. You see, you got less marks and then you say that you should be placed in top.
No, Lordship,
I would love it.
that is.
Because I would improve my what you call position in my metric examination, my graduation examination, my LLB examination. I always wanted to be first, but I got low marks. If you can help me,
If we go by these marks, then the person at serial number 3 and 5.
no, 3 and 5 is not before us, so we are not getting for them. right
However,
now.
I'm just trying to show my lordship that if we go by this, the injustice done to me, that is what I'm trying to impress my lordship. Although
No, we are against respondent number 4 and 5 and you. There are 3 people before us. You are placed below them since 14 November 2007. And therefore your position below the respondent number 4 and 5
Yes,
was
yes,
maintained
yes,
all throughout. Then you don't have a case.
lordship,
Because this is something which you are aware, but you did not produce before in the writ petition. Now in reply you are producing it, but it shows that even in 2007 you are below.
yes, this is what I am seeing from the respondents' documents, lordship.
Then
So I'm just trying to compare and contrast that if we go by this, they are claiming on this. If we go by this, then there is serial number 3 and 5 has to be.
no, for 3 and
It is
5.
for rectification of the, I have, my prayer is for rectification. Lordship, in the writ petition is page 12.
Yes, so far as the government is concerned, why the date of promotion should not be rectified, may not be what you call, we may not interfere with the seniority position. But why incorrect date should remain?
Your Lordship, as far as that is concerned, Your Lordship, that will be rectified, Your Lordship. However, Your Lordship, let the case of the effect of the case be projected properly. Then only, Lord, to that part, to that extent, Your Lordship, that will be rectified. But it is not going to, as correctly observed by this honorable court, it is not going to. Your Lordship, I'm having a problem, like I'm in my pregnancy. That's why, because of that, I couldn't able to.
Okay.
Your Lordship, my apology, Your
No,
Lordship.
it's okay.
Your Lordship, so correctly observed by this honorable court, Your Lordship, it is not going to improve the case as far as the respondent number 4 and 5 are concerned, Your Lordship, because it is only relating to the petitioner, the respondents have been promoted to the impositor, to the post of impositor in the year 2005, whereas the petitioner is, if we have to correct his debt, Your Lordship, it is 2006. So it is no way, Your Lordship, coming to respondent number 4 and 5. However, that can be corrected, Your Lordship.
10690.
Your Lordship, after the submission of my senior letter petitioner, your counsel, Your Lordship, I will submit, Your Lordship. I would like to bring the proper facts, Your Lordship, because some of the facts has not been properly projected before this honorable
But
court.
she's over. I don't think you have anything more to say. You have
It's just
anything
that,
more to say?
Lordship, I will wind up my submission for the time being, Lordship, just basing upon the service rule only. Whether it is legal for respondent number 4 to enter in a 100% departmental promotion post, or whether the respondent number 5, having been appointed after me, starting from the beginning, they have been prejudicing me, and I am backed by the service rule. Only those 2 rules, Lordship. So I leave to my Lordship's delegates.
No, incidentally, you know, the, why the word diligence is used.
Judicious,
Meaning
my
of,
lordship.
no, it is, the meaning of diligence is hard work.
Yes.
Correct.
My lord has to
Work
think
hard.
hard.
Okay,
and-
very good. Okay.
So I
Yes.
place my case along with the service rules.
Okay.
Lordship.
Yes, madam.
May I be pleased to Lordship, Your Lordship,
You, please give me your name. I am so forgetful. I am growing more old than I am looking. Your name, please.
my name is Livika, Your Lordship.
Livika, yes.
Your Lordship, now, my
I'm
senior-
sorry to the bar. I again express my apology to the bar. I am very forgetful of names, so I may be repeating
It's okay.
names, asking for names time and again. I'm so sorry.
of the respondent number 4 and respondent number 5. Your Lordship, I've brought my chart in page 5 of my affidavit in opposition.
Of respondent numbers 1, 2, and
My
3.
affidavit my affidavit is
Respondent
with
1, 2, and
respect to
3.
1 to 3, 1, 2,
yes.
and 3, Your Lordship.
Yes, yes.
The relevant page will be page 5, Your Lordship. I've brought out the chart, Your Lordship, there.
Page 5.
Yes, Your Lordship. So,
Yes.
yes, Your Lordship. So, Your Lordship, the serial number 1 that I have projected, reproduced is the petitioner, Your Lordship. The petitioner entered of service is 5/10/1999. He entered into service as an inkman in the year 1999, Your Lordship. That's an admitted fact, Your Lordship. Now, Your Lordship, I want to come back to respondent number 3, serial number 3, Your Lordship. I would like to come to that first, Your Lordship. Serial number 3, that is the respondent number 5. Your Lordship, respondent number 5 entered into service as a form carrier in the year 2000, Your Lordship. You got it, Your Lordship? As a form carrier in the year 2000. 1/6/2000, Your Lordship, in my chart, Your Lordship.
Yes.
Lordship, you got it? Now, Your Lordship, I maybe be allowed to state that, Your Lordship, the post of inkman as well as a form carrier. Your Lordship, these are the post, Lordship. Your Lordship is a feeder post to the next promotional post of impositor, Your Lordship. So they had
all these three,
No, no.
inkman, impositor, and form carrier, they are all feeder
no,
posts.
Your Lordship, the inkman as well as form carrier, that is the feeder post to the next promotional post of impositor.
post of
Okay,
impositor.
okay,
Yes.
okay.
So
Just-
that's
just-
why,
just-
Your Lordship,
Just a moment. Yes.
and Your Lordship, that is why, Your Lordship, the department maintain a different seniority list. The seniority list of inkmen is maintained separately, though they are the feeder post to the next promotional post for impositor, to the post of impositor, Your Lordship. The inkmen maintain a different seniority list, and the form carrier maintains a different seniority list, Your Lordship. Your Lordship, if we can kindly come to my affidavit, page 12, annexure 3. Page 12, annexure 3. Page 12, annexure 3, Your Lordship. Got it, Your Lordship?
Yes.
This is a seniority list as on 1/3/2004. As on 1/3/2004, it is published in 1st June 2000, June 2004, Your Lordship. Now the seniority position of respondent number 5 is listed at serial number 3, Your Lordship. The serial number of the respondent number 5 who entered into service as a from carrier is listed as serial number 3, Your Lordship. You got it, Your Lordship?
Yes.
Now, Your Lordship, my annexure 14, page 5. My annexure 5, page 40, Your Lordship.
Yes.
This is a seniority list of inkmen as on 1/3/2004. This was also being placed by our senior counsel, Your Lordship, for the petitioner, as on 1/3/2004. And the petitioner was placed at serial number 6, Your Lordship. As an inkman, Your Lordship, in the post of inkman, Your Lordship, the petitioner is appearing is figured at serial number 6.
Yes.
Yes, Your Lordship. So, Your Lordship, they maintain a separate seniority list, and basing on the seniority list, Your Lordship, the petitioner who was at serial number 3 as a form carrier was promoted first to the post of impositor, Your Lordship. And later on, the petitioner as entitled, he was also promoted as and when he was entitled, Your Lordship, and not as projected by the petitioner, Your Lordship. Because here, Your Lordship, the seniority position of the inkman, Your Lordship, he was at serial 6, whereas the respondent number 5, who was at serial number 3 of the form carrier, Your Lordship, he was promoted first because of that seniority list, Your Lordship. And Your Lordship, the petitioner itself has supported, and because the petitioner cannot deviate from the truth, Your Lordship. That's why, Your Lordship, she has also enclosed that as an when the respondent number 5 was appointed as promoted as an impositor, he was still an inkman. Because if you go by the writ petition, Your Lordship, as on 2006, in his writ petition, he has enclosed that as on 2006, Your Lordship, he was still an inkman at serial number 2, Your Lordship. Your Lordship, if you can kindly come at writ petition, Your Lordship, to satisfy this honorable court, Your Lordship. Your Lordship, page 21, annexure B3 of the writ petition. At this point of time, when the seniority list of 1/5/11/2005 came out, Your Lordship, the respondent number 5 was already an impositor.
That is 30 January 2006.
Yes, 30 January 2006, and the seniority list of inkmen as on 1/11/2005, that may be recorded, Your Lordship. 1/11/2005, the petitioner was still an inkman, Your Lordship, and he was at serial number 2, Your Lordship. And at this point of time, the respondent number 5 has already been promoted to the post of impositor, Your Lordship.
Just a moment. 1/8/2005.
Yes, Your Lordship.
Respondent number 4 was already an impositor.
Yes, Your Lordship. So they maintain a separate seniority list, Your Lordship. So as a form carrier, he was at serial number 3, so respondent number 5 got promoted. Now, from the document that the petitioner has produced, Your Lordship, as on 1/11/2005, he was still an inkman, Your Lordship. So where is the discrimination method by the government, Your Lordship?
Just you're referring to page 21.
Yes, Your Lordship.
Just
page 21 of the writ petition.
Okay.
And now, Your Lordship, the petitioner is stating that, Your Lordship, that he is aggrieved because of this promotion, Your Lordship. Has he challenged, Your Lordship? He has not challenged even this the promotion order of this respondent number 5, Your Lordship. So now, can he come before this honorable at this belated stage after 18 years? Can he come before this court and claim that I have been deprived, I have been aggrieved because of this promotion? Can he come before the, and that is also not mentioned. The basic order has also not been challenged by this.
He can come unless you show no. Unless you demonstrate that he can't come.
Your Lordship, it is evident, Your Lordship, because of this, the seniority list has been affected, and that is why he is coming before the.
You're posing us a question.
Yes, sir.
So I'm responding to that
yes,
question. Can somebody come to court? Yes. Answer is that we have never said no.
Yes, Your Honor.
Correct. Unless you show us why he cannot come.
Unless he is aggrieved, Your Lordship. If he's aggrieved, he should come, Your Lordship. Your Lordship, respondent number 5, petitioner actually accepted the position, Your Lordship. That is with regard to respondent number 5. Now coming to respondent number 4, Your Lordship. Coming to respondent number 4.
Yes.
Now, Your Lordship, as far as respondent number 4 is concerned, Your Lordship. Now to my chart, Your Lordship, the respondent number 4 was appointed as an impositor in the year 2005, Your Lordship, 1/8/2005. Now the petitioner is coming before this court stating that because of that service rule says it is 100%, Your Lordship. It is 2006, Your Lordship. And it is 100%. But if we strictly have to go by that rules, Your Lordship, his entry point is also questionable, Your Lordship, because the entry point to all this post is direct recruitment. I mean, the entry point of inkman as well as form carrier is also through direct recruitment, and that is also not being done in her case, Your Lordship. Yes, Your Lordship. So, you know, if it cannot be like this, that only the part that favors me, I will take it, and the part that does not favor me, I will not take it. That cannot be implemented, Your Lordship. If the petitioner truly wants to go as per the service rules, it has to be implied. We have to go back now. The petitioner is like it is ab initio. Then even his service will be ab initio because it has not been done through direct recruitment. Because it's already stated in the rules that it is 100%, Your Lordship. So if we have to implement strictly on the rules, then, Your Lordship, the petitioner cannot be allowed to take some part of the portion which is applicable to her, and some part which is not applicable to her, she will discard it. No, that will not be applicable, Your Lordship. My humble submission is that, Your Lordship. So, Your Lordship, and by the time when the respondent number 4 was appointed, Your Lordship, the petitioner was still an incumbent, Your Lordship. So how can the seniority position be affected, Your Lordship? Where is the question of superstition, Your Lordship? My question
What about R5?
Yes, Your Lordship.
What about respondent 5?
Respondent number 5 as a form carrier, as I have already said, Your Lordship, he was appointed as a form carrier in the year 2000, Your Lordship, admitted, Your Lordship. But as I have already stated, Your Lordship, they maintain a different seniority list. Form carrier and inkman, they maintain a separate seniority list, though the next promotional post is impositor, Your Lordship. They maintain a separate seniority list, and in the seniority list of form carrier, the respondent number 5 comes at serial number 3, whereas the petitioner in the inkman seniority list, he comes under serial number 6, Your Lordship. That is the reason why the respondent number 5 was promoted first to the post of impositor in the year 2005, and later on, as entitled, the petitioner was promoted to the post of impositor in the year 2006.
Respondent number 5 is page 14.
Page
14 of your affidavit. Let's come back to that.
Oh, Your Lordship, which Your Lordship, which one, Your Lordship?
No, you said position of a respondent number 5 is on 1/6/2004. Is it serial number? The petitioner is at serial number 6.
Yes, Your Lordship.
And respondent number 5. Respondent number 5 will not be here.
Not here.
No, their first appointment is enclosed by the petitioner, Your Lordship. I'm only talking about the seniority list as to how the respondent number 5 was promoted first, then then the petitioner, Your Lordship. That's why I have actually brought this Lordship to my affidavit, Your Lordship, in page 12 of annexure 3, Your Lordship, showing the seniority list of form carrier where the respondent number 5 has been figured as serial number 3. Your Lordship, may kindly revisit page 12,
Page
annexure
12,
3.
page
Yes,
12.
Your Lordship, of my affidavit in opposition, page 12, annexure 3.
Page 12, serial number 3.
Yes, that is the respondent number 5, Your Lordship.
Seniority
The
list as on
seniorities of-
1/3/2004.
Yes, form carrier. And if we can kindly come again, Your Lordship, to page number 14. Page number 14, annexure 5. This is the seniority list of Inkman, again as on 1/3/2004. The date is said, Your Lordship, 1/3/2004, 1/3/2004. The seniority of form carrier, and page 14, annexure 5. Seniority list of Inkman. You got it, Your Lordship? As on 1/3/2004, the name of the petitioner is listed at page 6, Your Lord, serial 6, Your Lordship. You got it, Your Lordship? Serial 6.
Yes.
So because of this, Your Lordship, because of this seniority position, Your Lordship, the respondent number 5 was firstly promoted to the post of impositor, then the petitioner, Your Lordship. Though it is an admitted fact that the petitioner has entry point as a form as an Inkman is prior to the respondent number 4, Your Lordship. Since they maintain a different seniority list, Your Lordship, that is how, Your Lordship, basing on the seniority list, the respondent number 5 was promoted first, Your Lordship. And therefore, Your Lordship, my humble submission is that, Your Lordship, there is no discrimination or superstition. The department, the government has rightly and correctly placed their names, in the seniority at the seniority place, in the seniority list, Your Lordship. And if we have to go, if suppose I have to go with the submission of the petitioner, Your Lordship, then, Your Lordship, the petitioner has to firstly challenge the basic orders. She has not challenged all these appointment orders, Your Lordship, and even the seniority list also. Now, Your Lordship, I would also like to come to the complaint letter. Now, the petitioner is saying that he has submitted a complaint letter, Your Lordship.
Yes.
Your Lordship, my page 18, annexure 9.
Page?
My affidavit in opposition, annexure 9, page 18.
Yes.
Your Lordship, now this is the as submitted by the petitioner, Your Lordship. The petitioner said that he has actually filed this complaint letter. I have categorically made a statement in my affidavit that we have not received this letter, Your Lordship. Moreover, even assuming but not admitting that this letter has been received by us, Your Lordship, it has been written to us after 2 months, Your Lordship. The complaint, Your Lordship, the seniority list, that the complaint against the seniority list 14 May 2007, Your Lordship. Page 17, annexure 8, Your Lordship. Page 17, my page 17, annexure 8. The petitioner has made a complaint against this seniority list, Your Lordship. And at the bottom, it has said, complaint, if any, should be submitted to the undersigned within 1 month from the date of issue of the list. If no complaint is received within the specified period, the list will be treated as final, Your Lordship. Now, the complaint letters, the so-called complaint letters submitted by the petitioner has never been received. And even if assuming but not admitting that this has been received, it is only received after 2 months, Your Lordship. So, Your Lordship, the seniority list that the petitioner is banning has a 10th finality, and therefore, Your Lordship, the petitioner cannot at this point of time bang on this complaint letter, Your Lordship. That is another submission, Your Lordship. Your Lordship got it? Now, Your Lordship, after they have been categorically, Your Lordship, promoted to the post of impositors, Your Lordship. The petitioner on 2006, the respondent number 4 as an impositor, the respondent number 5 as an impositor on 2005. After they have been to the post of impositor. Now coming back to the.
We'll continue post lunch because there's a meeting
Okay.
after some time.
Okay, Your Lordship.
So at 2 o'clock.
Okay.
Kita do 4 weeks. Motion to kali sabli here after 9. Ekta to date fix. Rishi 15-4. If not 4 weeks. Info. 2 weeks.
At least. Serial number 8. Mo itu apa sih kan dia boleh langsung hoy. Ini man kita dulu deh benar. Of course, it's my guess. Sure.
Of course or of course? No, sir, no. Either of course or of course. No? Anyways, at least at the disposal, it was some years, regardless of whichever way. The disposal is important. Need to do that, sir. Seniority. Pushkuna. Twenty-six below. 26 लिखे हैं।
Yeah.
Sure.
They have to see. They have to know.
Thank you so much for finding this.
Making you all rich. Making you all rich.
I'm sorry, there's a meeting, it took some time. Yes,
Lordship, may I be allowed to continue?
yes,
Lordship?
yes.
Your Lordship, now I would like to refer to my annexure 10, page 20, Your Lordship, of my affidavit, Your Lordship. Affidavit in opposition of respondent number 1 to 3.
Page,
Page 20, annexure 10. Got it, Your Lordship? The Lordship, now on 9th October 2007 and on 14/11/2007, a calling letter was given to the employees who were serving in the post of impositor, Your Lordship, and accordingly a capability test was conducted, Your Lordship, on these two dates, 9/10/2007 and 14/11/2007. And by this suitability test, it is apparent clear from this document that the respondent number 5 scored 17.5, Your Lordship. Serial number 2. The respondent number 5 scored 17.5. The respondent number 4, that is serial number 4, scored 11.5, Your Lordship. You got it, Your Lordship?
yes.
And the petitioner, who is at serial number 7, scored 10.5, Your Lordship. Your Lordship. So accordingly, on the next page, my page 21, annexure 11, Your Lordship. Page 11, page 21, annexure 11, Your Lordship. Next page. Your Lordship, on availability of vacancy to the post of printer, Your Lordship. The respondent number 4 and respondent number 5 were promoted to the post of printer in the year 2007, Your Lordship. And if I would like to draw your attention, Your Lordship, to the last portion, Your Lordship.
Yes.
Yes, Your Lord, the last paragraph, Your Lordship. Further, this promotion will not confer him, her any right to claim seniority. However, seniority will be determined as per merit of the capability test conducted on 7/10/2007 and 14/11/2007. Your Lordship. On the availability of vacancy, they were promoted. 4 and 5, they were promoted to the post of printers, Your Lordship. And their seniority will be subjected to this capability test. Now, Your Lordship, the petitioner is challenging this 2007 after a lapse of 16 years. Your Lordship, knowing the fact that the seniority is subjected to this capability test. But now the petitioner is coming before Your Lordship, stating that it is new to them, Your Lordship, the document is new to them. Your Lordship, they've in fact concealed the matter, Your Lordship. They have not disclosed the fact, this fact, Your Lordship, which is a determining point of their seniority. They have not disclosed that. And knowing this paragraph also, Your Lordship, it is in their knowledge, Your Lordship, but now they're making an argument that it is new to them and Your Lordship. So, and this has also not been put to challenge, Your Lordship. And so, Your Lordship, the question, and so basing on all these documents, as I have submitted earlier, Your Lordship, the petitioner, the respondent number 4 and 5 has been correctly placed above the petitioner, Your Lordship. And now by virtue of this, Your Lordship, I would also like to point out one point, Your Lordship, that is, previously, if we come by way of their promotion to the post of impositor, Your Lordship, respondent number 4 should be senior than the respondent number 5. But by virtue of this capability test, the respondent number 5 becomes senior than the respondent number 4. And all the seniority list that has been enclosed by the petitioner, in all this list, as per the capability test, the respondent number 5 appears senior than the respondent number 4 in light of this capability, in light of this result, Your Lordship, capability test result. Your Lordship, so Your Lordship, my humble submission is that, Your Lordship, the petitioner, all this, Your Lordship, the promotion to the post of printer is a consequential order, is a consequential promotion, Your Lordship. Otherwise, they have not actually challenged the basic order, Your Lordship. The basic order is that as in when the petition, the respondent number 4 and 5 were promoted to the post of imposer, the petitioner should have challenged, Your Lordship, that order. But without the challenging that order, Your Lordship, they are coming before this court after a lapse of 18 years, after a lapse of 16 years, if we have to take the year 2007, that is capability test. And if we have to take the year when they were promoted to the post of impositor, that will be a delay of 18 years, Your Lordship. So after a lapses of so many years, Your Lordship, after more than a decade, Your Lordship, the petitioner is coming before this court challenging 2007 as well as the seniority of 2023, Your Lordship. So, Your Lordship, how can the petitioner come before this court without any justifiable reason and settle the unsettled position? That is my submission, Your Lordship. And therefore, Your Lordship, the petitioner's case does not survive on the facts and circumstances I have narrated, Your Lordship, and the petitioner's, cases suffers from delay in laches, firstly, and second, for not challenging the basic orders, Your Lordship, and therefore, his case should be outrightly rejected, Your Lordship, dismissed. And in support of my case, I want to submit one ruling where the Supreme Court, the Apex Court, has decided that when a matter has come after a considerable period of time and when the promotion has been affected, it should not unsettle the settled position. I would like to submit you.
What is the name? What is the citation?
Citation is, Your Lordship, 1998, Volume 2, SSC 523, Your Lordship.
1998?
1998, Volume 2, SSC 523, Your Lordship. It's between B.S. Bajwa and another versus State of Punjab and others, Your Lordship. Your Lordship, if you can kindly allow me, I would like to read the operative portion, Your Lordship.
Yes.
The operative portion is at para 7, Your Lordship. I will just read this paragraph and then conclude my submission, Your Lordship. Your Lordship, may I be allowed to read, Your Lordship? Para 7. Having heard both sides, we are satisfied that the writ petitions was wrongly entertained and allowed by the single judge, and therefore the judgment of the single judge and the division bench have both to be set aside. The undisputed facts appearing from the records are alone sufficient to dismiss the writ petition on the ground of laches because the grievances was met by B.S. Bajwa and B.D. Gupta only in 1984, which was long after they had entered the department in 1971-72. During this entire period of more than a decade, they were all along treated as juniors to the others aforesaid persons, and the right inter se has crystallized, which ought not to have been reopened after the lapse of such a long period. At every stage, others were promoted before B.S. Bajwa and B.D. Gupta, and this position was known to B.S. Bajwa and B.D. Gupta right from the beginning as found by the division bench itself. It is well settled that in service matters, the question of seniority should not be reopened in such situation after the lapse of reasonable period because that results in disturbing the settled position which is not justifiable. There was inordinate delay in the present case for making such grievances. This alone was sufficient to decline interference under Article 226 and to reject the writ petition. Your Lordship, in view of this, Your Lordship, my humble submission is that there was no discrimination on the part of the government, but as rightly project have been submitted before this Honorable Court, Your Lordship, as to how they were promoted, as to how the seniority list come into effect, Your Lordship. We have rightly and correctly projected the seniority list, Your Lordship, in light of their entitlement, and not as projected by the petitioner, Your Lordship. And therefore, Your Lordship, the petitioner is just coming before this court with some facts which has been relevant to them, but that is not the entire fact. And the fact that I brought, it's apparent on the record, Your Lordship. And therefore, on these grounds, Your Lordship, the petitioner's case does not survive, Your Lordship. And while recording my submission, Your Lordship, the affidavit that I have written in para 5, 7, and 10 will be relevant, Your Lordship. Para 5, 7, and 10 of my affidavit in possession will be relevant, Your Lordship. Your Lordship, that's on my part.
Yes. Yes, please, Javeed. You are for?
I for respondent number 4. And my learned friend Joshua is for respondent number 5. And I wish to confine to the case pertaining to respondent number 4. There is no point cutting a falling tree, but then I want to ensure myself that the tree is really fallen. The writ petition is founded on a misconceived idea, in the sense that the bone of contention of the writ petitioner is he has been appointed in the year 1999 as an inkman, and both respondent number 5 as well as respondent number 4 were appointed much after his appointment. I will confine only to the appointment of respondent number 4. Respondent number 4 was appointed in the year 2005. The particulars my learned friend has already given, so I'm not referring to that. In the post of impositor, that is a promotional post of inkman. So although he was appointed in 1999, it was in a post which is in the lower rank. And my appointment is in the year 2005 to the post of impositor. Only when he get promoted to the next higher post, then the place where I'm sitting, he will also get. In other words, he will born in the gather only when he get promotion from the post of inkman. And my learned friend started her submission with a contention that
you were appointed when?
2005. My appointment was on 1/8/2005 to the post of impositor. And the petitioner's appointment to the post of inkman was 5/10/1999. My learned friend has started his submission that my appointment is illegal in the sense that the provisions of the service role, as per the service role, the post of impositor is a promotional post. That is the submission my learned friend has made. Now, Lord Chief, all the appointments were prior to the enactment of any role. The first draft service role was in 2006 and 7. I do not know, but latest is 2006 and 7. They're up the earliest. And then 2015 rules, 2022 rules. So all 3 appointments, the petitioner, respondent number 4, and respondent number 5 appointments were all before the service role came into force. Therefore, the contention that my appointment and as well as the appointment of respondent number 5 is contrary to the rules cannot hold any water, inasmuch as there was no service role in existence during that time. But in order to portray her submission so as to impress this honorable court to show that the service role has been violated, there was no service role at that time. Now, since my learned friend, the learned government advocate, has also made the submission that if we are to go to the initial appointment, then the appointment of the petitioner is also an issue. Now, I'll bring an example. Now, all the grade 4 employees, grade 3 and 4 employees in the state of Nagaland, the government came out with an act and as well as the rules that all grade 3 and 4 appointment shall be recruited through Nagaland State Selection Board, NSSB. Now, if a person come and say that, look, as per the NSSB rules and regulations. You are not appointed in accordance with the rules, whether that can be sustained or not. Role is, or any law enactment is always prospective in nature. And unless there is provisions in the service rule that it will have retrospective effect from a particular day, it will have no retrospective effect. Therefore, the submission of my learned friend that the initial appointment of respondent number 4 is not accordance with rule has got no relevance at all. That is the reason why I'm submitting that it is absolutely misconceived. The writ petition is based on a misconceived ground. That is one. Secondly, think of the defects. Another defect, very fundamental defect. My learned friend, learned counsel for the state has made a submission that the basic order has not been challenged. I also support the same submission. Rather, the consequential order has been challenged. That is our promotion. But Lordship may kindly come to my affidavit. That is affidavit in opposition of respondent number 4. Page 20. Annexure H. Has your lordship correct? And affidavit in opposition of respondent number 4, page 20, annexure H. I will just refer to the relevant paragraph. This is the promotion order to the post of printers, which was issued on 18th of December 2007. My learned friend has already referred to, but I will refer to the last portion. Further, this promotion will not confer him/her any right to claim seniority. However, seniority will be determined as per the merit of the capability test conducted on 7 October 2007 and 14 November 2007. This promotion order is under challenge. And Lordship may kindly see the pre-page, that is page 19. Annexure G, page 19. This is the minutes of the capability test for promotion to the post of printers held on 9 October 2007 and 14 November 2007. And my learned friend has made the submission that although they have challenged the promotion order to the post of printer, this document, that is Annexure G, page 19, was not made available to them, and it came to their knowledge only when the government filed counter affidavit. If I have understood correctly, that was the submission made. Now, the question is, when there is a clear mention in the document which was challenged by them, it is clearly mentioned that the seniority will be determined as per the merit of the capability test conducted on 7 October 2007 and 14 November 2007. It was very much within their knowledge. The fact that the test was conducted in 2007, it was within their knowledge because they have challenged this order, this promotion order. Then how come it was not within their knowledge? Therefore, they have contradicted themselves. And if at all they are questioning my appointment orders, see the prayer in the writ petition, what they have challenged. If at all, any interference or any doubt, any question is to be raised on my appointment, whether the writ petitioner has challenged my appointment order, what are the prayers in the writ petition? Page 11, question set aside the ambient seniority list 14/4/2023 and or rectify the ambient seniority list 14/4/2023 in accordance with law. B, ambient common order dated 18/12/2007 in respect of promoting the respondent number 4 and 5 as renders. This is the promotion orders. So these are the only prayer they have made in the writ petition. Lordship is well aware that in a writ proceeding, the High Court cannot go beyond the prayers made in the writ petition. Relief cannot be granted beyond the prayers. Therefore, that count is also closed. That door is also closed for the petitioners. Now, the challenging of this 2007 promotion has reminded me of one old story. Rip Van Winkle, who has slept for 20 years, the petitioner has been sleeping for the last 18 years, only 2 years short of the Rip Van Winkle, who has slept world record of 20 years. So in the late of the day, whether this honorable court will reopen and unsettle the settled things, that too in a seniority issue.
No, from your submission, we'll have to take care of it. And we'll have to entertain the, what you call this petition. Because if we all remember Rip Van Winkle for sleeping 20 years, why we should forget this petitioner who has slept for 18 years?
Lordship,
in a match, there has to be a first, then there has to be a second.
Lordship may recall another example. If a mistake is committed in the past, that cannot be a ground to perpetuate the same illegality. So if Rip Van Winkle has slept too long, that should not be the example for the petitioner to sleep. Anyway, Lordship, let me just wind up because there is nothing much to be considered keeping in view of all these infirmities in the writ petition. Firstly, service role will have no application. I'm not referring to all the documents because my learned friend, 2 of my learned friends have already referred to all the documents. So the contention about the application of the service role will have no application because all our appointment is prior to the rule came into force. The first draft rule was sometime in 2006-07. That is after our appointments. And then the initial appointment of the petitioner, although he is earlier in point of time, it was in a lower post. And so far as respondent number 4 is concerned, I'm appointed in 2005 to the post, to a higher post. Therefore, the contention that I'm appointed first, then the respondent number 4 do not hold any water. And then the promotion to the post of printer in 2007 is based on a suitability test conducted in 2007. That was not challenged by the petitioner. Therefore, without challenging the basic order, challenging only the consequential order will be of no consequence, Lordship. So, and then, therefore, Lordship, going by the pleadings of the writ petition, whatever my learned friend has submitted is not founded under pleadings. So far as my appointment, so far as the application of rules are concerned, these are not in the pleadings, but it's more like an afterthought that after filing the writ petition only, just in order to convince the Honorable Court, they are referring to the service rule, but as I have submitted earlier, this will have no application, Lordship. Therefore, whatever has been settled should not be made to be unsettled, and the petition has been filed with the misconceived idea. Therefore, the writ petition deserves to be dismissed with heavy cost, Lordship. With that, I conclude.
Will please, Your Lordship, I adopt the submissions of the Council for the State as well as my learned senior colleague for the respondent number 4. I only have to point out 1 or 2 points to Your Lordship because my Lord has heard enough and is already in siege of the moment of the case. May I take Your Lordship to The affidavit of the respondent number 5, annexure D. As my lord got a page number 18, annexure D. The affidavit of the respondent number 5.
Yes.
My lord, this is the calling letter for conducting the capability test. Everybody has received. So apparently the petitioner who has not annexed has either suppressed the material fact or may have misplaced the documents, but these are the facts that led to the conduct of the capability test, which my learned friends have already mentioned that I would not be insisting upon, your lordship. Now, my lord may also kindly take note of this. The petitioner, he was promoted to the post of impositor, White order dated 1/8/2006, your lordship. Whereas the respondent number 5 has been promoted to the post of impositor, White order dated 3rd November 2005.
Please come again.
3rd November 3, 2005. The petitioner was, the respondent number 5 was promoted to the post of impositor, White order dated November 3, 2005. Whereas the petitioner, he was promoted to the post of impositor.
3rd November 2005.
Yes, that is the respondent number 5, my lord. 3rd November 2005. The petitioner was promoted to the post of impositor, White order dated 1/8/2006. The promotion of the respondent number 5 was never in question at any point of time, lordship. Number 2, my lord, as has been already pointed out, after the capability test, my lord may kindly appreciate this fact. The printing and stationery department is a technical department, lordship. The technical know-how is very important. So that is why in the test which was conducted, the petitioner unfortunately could not be in the merit list, could not be above any of the respondents, the respondent number 4 and 5. So he's rightly placed below them, your lordship. The mark scores, my lord, has already seen. Now, my lord, promotion to the post of impositor was never challenged. Number 2, promotion to the post of printer, which my learned friends has already pointed out that I'm not reiterating, lordship, to waste the time of this own court, but my lord has already seen it. The same has also never been challenged. There has been subsequent seniority lists that has been published over the years. The only seniority list that is under challenge before this own court is the seniority list of 2023. All the documents on record have attained finality, my lord. So at this stage, the case been hit very badly by delay in laches. Lordship, the petition itself is not maintainable. Further, the last point that I'd like to stress before your lordship.
Which is the seniority list under challenge?
The only seniority list under challenge is the seniority list of 2023, my lord. 2023. None of the previous seniority lists have been questioned. And my lord is fully aware by the settled principle of law that you may submit hundreds of representations, but until and unless you approach the appropriate forum, lordship, representation is not a remedy for the whatever grievances that the petitioner may be raising, my lord. Now may I take a lordship to page 28, annexure L of my affidavit. Your lordship, this is the order dated 15th September 2017. by this order, the services of the respondent number 5 as well as the respondent number 4 has been confirmed.
Page?
Page 28, my lord, annexure L. Annexure L.
Of your affidavit.
Yes, my lord, the respondent number 5's affidavit. Our services have been confirmed by the order dated 15 September 2017. The respondent number 5 is at serial number 1. The respondent number 4 is at serial number 2, my lord. Our service has been confirmed nearly 5 years, more than 4 years prior to the confirmation of the service of the petitioner, my lord, which is at annexure K of the writ petition at page 48. The 19th April 2022, his service was confirmed nearly 5 years after the confirmation of the service of the two respondents, private respondents, my lord. None of these documents.
What is the date?
My lord, our
No, there.
19th April 2022, lordship, service confirmation. That's nearly 5 years after the confirmation of the service of the respondent number 4 and 5. When none of these documents have been questioned at any stage, lordship, the petition unfortunately suffers from the irreparable infirmities, incurable infirmities. May I place two short authorities before your lordship? 2013 12 SCC 179. 2013 12 SCC 179. Lordship, I am referring to the para 26, 27, 28, and 29. 26, 27, 28, and 29. May I read, my lord? May I read, my lord?
Yes, yes.
The para 26. Presently sitting in the time machine, we may refer to a two-judge bench decision in PS Sadasi Swami versus State of Tamil Nadu, wherein it has been laid down that a person aggrieved by an order of promoting a junior over his head should approach the court at least 6 months or at the most a year of such promotion. It is not that there is any period of limitation for a court to exercise the powers under Article 226, nor is it that there can never be a case where the court cannot interfere in a matter above after the passage of certain length of time, but it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 in the case of persons who do not approach it expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward stale claims and try to settle settled matters. 27. We are absolutely conscious that in the case at hand, the seniority has not been disturbed in the promotional cadre and no promotions may be unsettled. There may not be unsettlement of the settled position, but a pregnant one, the respondents chose to sleep like Rip Van Winkle, my senior colleague has already said, and got up from their slumber at their own leisure, for some reason which is fathomable to them only. But such fathoming or reasons by oneself is not countenanced in law. Anyone who sleeps over his right is bound to suffer, as we perceive. Neither the tribunal nor the High Court has appreciated these aspects in a proper perspective and proceeded on the basis that the junior was promoted and therefore the seniors cannot be denied a promotion. 28 and 29 is all the more the same, Your Lordship. Now, I may be allowed to refer to another judgment, Your Lordship. The other authority that I'm referring to is 2011-5 ACC 607, page 607. I'm relying upon the paragraphs 46 to 52. My lord, so very short paragraphs, but I may not read the whole paragraphs, my lord.
Just a moment.
46 to 52, 2011-5 SCC 607. May I read, my lord?
Para
Para
46
46 to 52, my lord.
Yes, please.
46. Delay in laches is one of the factors that requires to be borne in mind by the High Court when they exercise their discretionary power under Article 2 to 6 of the Constitution of India. In an appropriate case, the High Court may refuse to invoke its extraordinary power if there is such negligence or omission on the part of the applicant to assert his right, taken in conjunction with the lapse of time and other circumstances. 47. The Privy Council in Lindsay Petroleum Co. versus Heard, which was approved by this court in such and so case, has stated, now the doctrine of laches in courts of equity is not an arbitrary or technical doctrine where it would be practically unjust to give a remedy, either because the party has by his conduct done which might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. But in every case, if an argument against relief, which otherwise would be just, is found upon mere delay, that delay, of course, not amounting to a bar by any statute or limitation, the validity of that defense may be tried upon principles substantially equitable. Two circumstances always important in such cases are the length of the delay and the nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking one course or the other, so far as it relates to the remedy. And in both the conditions, my lord, circumstances, petitioner has failed, lordship. Then, lordship, paragraph 48. In Amrit Lal Berry versus CC, this court took the view that if petitioner has been so remiss or negligent as to approach the court for relief after an inordinate and unexplained delay, it certainly jeopardizes his claim as it may become inequitable with circumstances altered by lapse of time and other facts to enforce a fundamental right to the detriment of the similar claims of innocent third persons. So, lordship, the further paragraphs are all the more the same on the same principle, my lord. That is my humble submission, your lordship.
May I please, your lordship? I need to make a first submission on one issue, your lordship, because it's our duty to assist the court. Your lordship, as far as the rectification part on the April 2023 seniority list, the petitioner was promoted to the post of impositor on 8/8/2006, but it is projected as 1/8/2007. So on that part, your lordship, we will make a rectification, your lordship. But as I have stated earlier, even if we make this rectification, this is not at all or in any way going to affect does not come in the way of the respondent number 2, 4 and 5, your lordship. And another thing, your lordship, clerical error has also been done on my affidavit in opposition. It's 8, but it's written 1, so that may also be look into topographical, your lordship, error. In my affidavit in opposition, I have given your lordship chart, your lordship, page 5. Affidavit in opposition filed on behalf of respondent number 1 to 3, your lordship, page 5, your lordship. On the chart.
Yes.
It's written 1/8. It should be 8/8, your lordship. It should be 8, not 1, your lordship. Topographical mistake, your lordship.
For respondent number.
Petitioner. The impositor, to the post of impositor, Your Lordship.
1-8. It should be
It should be 8, Your Lordship. So, Your Lordship, in this regard, we will make a rectification.
Hey, please, my lord. Since my lordship is thorough with it, I won't say much. It's just that the Ghana government advocate has here in this matter it's a limited list of form carriers as well as this equivalent post of inkmen in the first place were separately maintained. So when those two from separate channel is combined into one channel, lordship, here it's not that the petitioner was at serial number 6 when he was in the post of inkman. She has related that at serial number 6, whereas the respondent number 5 was at serial number 3. That's why promotion was given to the respondent number 5 in the first place. That is what she has submitted. But within the perspective of the service rule, when it is combined together, the date of appointment has to be considered for seniority, but they did not do that. And they promoted the respondent number 5, who was appointed after the petitioner, that is first. Then they say that after 2 months, I submitted my complaint, but seen from the document itself, no official personal copy was served, and only after when I came to office, I saw that say a new seniority list has been issued, and that's why I submitted my application through. And on that day itself, when I came to know it, I submitted this, but without any proof.
In fact, this will be the first person I know of who has got promoted but did not know about it.
Seniority list.
Seniority list.
Seniority list.
He'll not know about it. First person.
Nevertheless, lordship, 2007, yes, they are saying that there is delay in laches, but when from the beginning itself, in violation of the service rule, okay, even assuming that there was no service rule in 2006, when they were appointed, but in 2007, when the promotion were made, the service rule in 2007, although this is a draft service rule, it was already enforced. But lordship, I just want to just clarify that even after the enforcement of the service rule of 2006, I submitted my representation, but 2007, but they just continued, and prior to their promotion, I have already submitted my representation, but that was not considered, and they promoted the 2 respondents. By now, my lordship has already made up my lordship's mind.
Am I so transparent?
And there is no limitation in filing writ petition when the very service rule is violated. Lordship, they are saying that I have delayed, I have done this, I have done that, but when the service rule is there and it is in absolute violation, both the respondent, in view of the fact that the first appointment is the basis, that is the basis of the counting seniority. The service rule itself provides, and in there, it is 2006 is also there. I have shown 2007, but 2006 and 7 are almost all the same, lordship. There is no differences, even the rules, clauses. So, lordship, it's very clear from the service rule itself, seniority in the gather shall normally be determined with reference to their date of joining in that gather, provided that seniority of the promoted shall be determined in order of preference given by the committee.
Now, where is the violation? Where is the violation? If you take that provision, where is the violation? Which document you show? Please show us.
Seniority in the gather shall be normally be determined with reference to their date of joining, means date of first appointment. That is what I just want to.
Yes.
Date of first appointment. So the first appointment is, both of them were appointed after me. Lordship,
No, no,
I-
no, no, no. Date of appointment in the cadre, you read that. And therefore tell us where is the violation.
Violation is that of joining in that cadre. I joined first and they joined after me. Respondent number 5.
In which service law you have come across in the state of Nagaland, where it says that a feeder cadre, unless a person in the feeder cadre are appointed on the same day, they will not be, they'll be unequally considered. You see, let us say you forget these things, forget this service. Let us say that in one office there is three posts,
Lordship.
A, B, and C. A, B, and C are feeder cadre to D. Now, where does it say that unless feeder cadre in A, B, and C are appointed on the same day, or they are unequally positioned, that means date of joining is different, then the first date of joining shall get preference. And in the feeder cadre, the persons in the other cadre who have joined service later in point of time shall be deprived. In which service rule have you found this?
Lordship, it's not about depriving, but since 2007.
No, forget my language. You see, I may be making a mistake in the language. But the point I am trying to make is that if there are three feeder cadres, is it the law in the land that in different cadres, different people appointed in different point of time will not get appointment unless they are first in point of time? That means in cadre A, somebody is joining on 1st January 2017. In cadre B, someone is joining on 2nd January 2017. Third is joining on 3rd of January. So is it the law of the land that only 1st January will get the first preference, 2nd January will get the second preference, 3rd January will get the third preference?
Lordship, I leave it to my lordship's wisdom, but it's.
Oh no, when it comes to wisdom, I'll tell you something. You have Evidence Act. Evidence Act.
Lordship, it's just that even if there is no.
No, I'll show you something.
Lordship, I need not see it, Lordship.
No, you have to, because otherwise you won't be able to reply. But this is a provision I remember, but it may be new to you. Please see that, section 57.
Lordship, I need not see it. I leave to my lordship wisdom and.
No, there is a reason for it. I'm imploring on you. Please read that.
57.
Section 57. Even at your displeasure, I'll still request you to read it. Section 57 is facts of which the court must take judicial notice.
Lordship.
Correct.
Judicial notice of the following facts, all those in person.
13. There are 13. ABCD, there goes to 13. After 13, you see there's a proviso.
In all cases, and also on all methods of public history, literature, science, or art, the court may resort for its aid to appropriate books or documents of reference.
Correct. Now, second.
If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produce any such book or documents as it may consider necessary to enable it to do so.
Yes. So you see, there are two things coming out. Number one, not knowing law is not an excuse for a citizen, correct? Any dispute? No. Not knowing law is not a excuse for a citizen, but it is an excuse for a judge. A judge is not required to know law. This is what the proviso in section 57 says. Therefore, you may tell us that this is the law, but we can refuse to acknowledge that unless you show us a book. So therefore, don't always throw everything to the wisdom of the court, because it may have none.
Lordship, but another one, the learned senior advocate has said that.
And that is why I'll try to link one more aspect. You have seen the statue of law. It's a lady with her eyes closed, and it has a balance in the hand. So therefore, a judge is not required to know things. He will have to weigh things in the scale of the balance of scale, and then adjudicate. So therefore, don't throw everything on the court. I told you I may not have wisdom.
That is also
your expectation.
That is also one aspect. It's just my humble submission before the Seniority Court is that yes, this seniority list were all in different districts. One is Mokokchung, Dimapur, and Mokokchung, Dimapur, and Kohima. There were 3 printing press offices, and so only when the combined seniority list was issued, only then became of our status, Lordship. Combining all the 3 districts, otherwise separate seniority list was maintained in the district. There are 3 printing press offices. So when the first, my just humble submission is that when the first seniority list was issued, immediately when I was placed below, I submitted the representative complaint letter. So that is my just up to that extent only, Lordship. And when after my submission of complaint letter, when that on 777, and when in December after 2 months, their promotion order was issued. Since I had submitted complaint letter, it was issued. That's why I just made it a challenge. And from that aspect, all of us are now in printer post without any dislocation or so. So within my perspective, limited knowledge, Lordship, I thought that since there is no further action till 2007, no promotion has been affected, no step has been taken. That's why since from the beginning, with ab initio, the seniority list, and my lord has seen in all the, how can they make a mistake when I was promoted in 2006, but they keep on, this is not a clerical mistake, but that kind of action has been done by the respondent government. Till my submission of another representation, they rectified it to 8816, but then in the final in 2023, again they went back. This clearly shows that they have some malafide against me, and they have been changing my date of promotion to the post of impositor. That is how, Lordship, I was discriminated. That is my humble submission before the Honorable Court. They could not have made such kind of mistake for 4 years continuous in the seniority list. Then they rectified for 2 years. Again, they went back and make it into another, the letters to 2023. Lordship, for the respondent government, they can say anything, and they can say that I did not submit the representation or whatnot, but since it is apparent on the face of record, I have placed before my lordships that since 2007, no steps has been taken, and at least since there is a service rule thereafter, and since it is before the court, Lordship, in my humble submission that there may be some rectification. That is all I sought for. Otherwise, Lordship, that will be my submission before the Honorable Court. And
Which page is your representation?
My first representation.
No, not first, last one.
Last
This
one
is Annexure J.
One is 6/10/2020 is annexure 41 page.
No, last one. Last one is page
last
46, I believe.
Last one is,
Page 46, is it? That is your last one?
yes, Lordship. All have been promoted to printer post without any disturbances in an equal status, Lordship. That's why I thought that the previous mistake can be rectified. That was my humble thought, Lordship, when I approached this honorable court. They cannot keep on perpetuating illegality, if I am to say. That is my humble submission before this honorable court.
This but interestingly, the date of your promotion to 1/8/2007, you have not made a prayer to rectify it and bring it to 8/8, because you are happy with 1/8. It gives you 7 days of seniority.
Lordship, 8/8/2000.
No, so therefore you say that promotion was made on 8/8, but in the
My
senior.
promotion, the
but-
documents are there, Lordship.
But promotion as per the seniority list is given on 1/8. That means you are given 8 days promotion. That is why you are not challenged it. Incorrect entry was not challenged. So you are happy with this error.
8806, whether it is 8806 or 106, that does not change my status.
No, it's
as
not
to my
that.
seniority.
No, it's not that, but still you are not assailed that.
They have given it 888 August 06. They have given it as 8806. In the two rectification, they have given 8806. Page 22 annexure C. So they have taken this 8806.
Okay, yes.
Obliged, my lord.
But Mrs. Z. Zimubi, learned counsel for the petitioner. Also heard Ms. Livika, learned government advocate, appearing for respondent numbers 1, 2, and 3. And Mr. Siti Jamil, learned senior counsel, assisted by Mr. I. Imchen, learned counsel for respondent number 4. As well as Mr. Joshua Sheki, learned counsel for respondent number 5. Next, the once again, the question as to whether delay and laches on part of the petitioner to approach this court would disentitle them to discretionary power of the court under Article 226 of the Constitution of India has been raised by the respondents in the present case in hand. Next, brother. By filing this writ petition on Article 226 of the Constitution of India, the petitioner has challenged the seniority list dated 14/4/2023 of printer as on 1/4/2023 with alternative prayer to issue direction to the respondent authorities for rectifying the seniority list dated 14/4/2023 in accordance with law. Full stop. The petitioner has also assailed the common order dated 18/12/2007 insofar as it relates to promotion of the respondent numbers 4 and 5 as printers. The petitioner has also prayed for directing the respondents to bring out a fresh seniority list of printers in accordance with law and to hold a fresh DPC and consider promotion of the petitioner as deputy foreman by issuing a fresh seniority list of printers or as per rectified seniority list. Next paragraph. Before adverting to the case of the petitioner, it would be pertinent to mention that in the establishment of the Directorate of Printing and Stationery, Government of Nagaland, for the post of printer, which is to be filled up by promotion, the post of impositor and
Form carrier. Form carrier.
and form
Carrier.
what is it spelling?
CARRIER.
Oh, form carrier.
Yes.
Form carrier are the feeder post. Full stop.
The post of inkman and the form carrier is the feeder post to the next promotional post of impositor, Your Lordship.
So for the printer, which is the it is only from
From the post of impositor to printer.
Acha, only impositor is the feeder post. Full stop. However, for the post of impositor, comma, the feeder posts are inkman, form carrier. Are the feeder post. The feeder post are so and so and so and so. Full stop. The next part, the case of the petitioner is that he was first appointed as inkman in the said establishment on 5/10/1999. Full stop. By referring to the seniority list of inkman, comma, it is projected that the name of the petitioner appeared at serial number 12.
13, Lordship.
No, 12 as on as per the seniority list as on 1/9/2001. Full stop. The learned counsel for the petitioner has referred to subsequent seniority lists No, first is, I made a mistake. It was first is 1/9/2000, where the name of the petitioner is at serial number 13. And in the second seniority list of inkpen as on 1/9. Sorry, 19/9/2001. The name of the petitioner is serial number 12.
My name is at serial number 13, Lordship.
No, it's just 13 is twice.
Yes, twice in 2000 and 2001.
So it can't be 13, it has to be 12.
Oh, Lordship, there is no.
Correct.
12. Yes, yes, there is no 12.
It's a timing mistake.
12 is missing.
And you should thank your department for it.
But once that again, 13.
There are two 13s, so I'm considering you to be 12.
Yes, yes.
Correct. First, the counsel for the petitioner projects that in the seniority list, which is prepared up to 30 January 2006, comma, the seniority list only contains the name of the petitioner, and the name of respondent numbers 4 and 5 have not found place in the said seniority list. Accordingly, it is submitted that thereafter on 22/8/2000, on 8/8/2006, the petitioner was promoted to the post of impositor, IMPOSITOR. However, in the seniority list prepared as on 31/12/2006, the name of respondent numbers 4 and 5 were placed senior to that of the petitioner, and the respective position of the and their respective positions were at serial number 2, 6, and 8 respectively. First, it is the case of the petitioner that the position of the petitioner remained below that of respondent numbers 4 and 5. Full stop. Next paragraph. The petitioner made a complaint on 7/7/2007 with regard to her position in the seniority list. But though the petitioner was promoted to the post of printer on 18/11/2010, the seniority position, the interstate seniority position with vis-a-vis respondent numbers 4 and 5 remained unaltered. And the position remained in the periodical seniority lists, which were published as on 17/7/2017, 27/2016, 17/7/2017, 1/4/2018, 1/4/2019, 1/4/2020, and thereafter the respondent numbers 5 and 4 respectively were promoted by order dated 18/12/2017. Stop. The learned counsel for the petitioner submits that it is only after the said promotion order no, this no, just strike out the promotion order. So thereafter, a complaint was made by the petitioner. On 6/10/2020, but still the seniority position of the respondent numbers 5 and 4 respectively was placed before the petitioner as on 1/4/2021 and 1/4/2023. And accordingly, by filing this writ petition, the seniority list has been assailed by the petitioner. Next, the learned counsel for the petitioner has submitted that the first complaint was made on 7/7/2007, and as her position was, and as the position of the petitioner was not altered, a subsequent complaint was made on 6/10/2020, and thereafter the petition was filed. Stop. It has been submitted that the seniority position of respondent numbers 4 and 5 cannot be permitted to be legalized. And therefore, the present challenge was required to be entertained, and the wrong committed to the petitioner ought to be ought to be altered and corrected by setting aside the promotion orders of respondent numbers 4 and 5. Full stop. For contra comma, the learned government advocate has referred to the stand taken in the affidavit in opposition of respondent numbers 1, 2, and 3. And it was submitted that while Inkman and form FORM carrier is the feeder post for imposter, as on 1/8/2005, the respondent number 4 was already appointed and working as an imposter. Accordingly, it is submitted that the seniority position of respondent numbers 5 and 4 respectively was always positioned before the petitioner this respondent number 5 became respondent 5 was appointed when respondent number 5
was appointed as form carrier as on 2001/6/2000.
the respondent number 5 was appointed as form carrier
Carrier,
on
1/6/2000, Your Lordship.
1/6/2000.
2000, Your Lordship.
First, it is submitted that the separate seniority lists were maintained for the feeder post of Inkpen and form carrier,
Yes, Your Lordship.
and the date of appointments of the respondent numbers 4 and 5 are already indicated in the respective seniority lists. And in this regard, the learned government advocate has referred to the seniority lists where are those seniority lists? Those seniority lists.
The seniority list of form carrier is at annexure 3, page 12, Your Lordship.
Page?
Page 12, Your Lordship, annexure 3.
Page 12 of the writ petition.
Of my affidavit in
Of your
opposition.
affidavit. Just
Lordship, respondent number 1 to 3.
please. As referred to annexes to the affidavit in opposition by respondent numbers 1, 2, and 3
Page 12, annexure 3.
Ah.
That is the
To
seniority
show that
list.
the name of respondent number
5.
5
5 is at
was at serial
three.
number 3
Yes, Your Lordship.
in the seniority list as on 1/3/2004
Yes, Your Lordship.
and
And annexure,
and
annexure
as
5.
Inkman, the seniority list as on 1/3/2004 contained the name of the
Petitioner is
petitioner at serial number 6
6.
as Inkman.
Yes.
Stop. Next one. The learned government advocate has submitted that Mr. Sheikh is told that this call letter
Your Lordship, Your Lordship, a suitability test is
call
page
letter
20.
21/9/2007. 21/9/2007. Where is that?
My lord is talking about a calling letter.
Call letter
Calling letter.
21. You had given a date 21/9. I forgot to mention in.
Yes, my lord. It's 21 September. Yes, 21/9/2007.
But where is that document?
My lord, it's in my affidavit.
Which
for the
page?
Respondent number 5.
Which page?
Page 18.
Page 18, lecture D.
Affidavit to respondent number 5.
Ah, yes. So it was also submitted that a capability test was conducted amongst impositors to fill up the post of printer. On 9/10/2007 and 14/11/2007 respectively, where the respondent number 5 obtained the marks of
17.5. Serial number 2.
of 17 1/2, 17.5. And the respondent number 4
11.5.
scored the marks of 11.5, while the petitioner scored marks of 10.5. Accordingly, it is submitted that in the seniority list of printers, the name of respondent numbers 5 and 4 was maintained above that of the petitioner.
Yes.
Stop. Referring to the documents annexed to the affidavit in opposition, of respondent numbers 1, 2, and 3. It was submitted that in the promotion order dated 18/12/2007 it was clearly mentioned that the promotion order would not confer any right to claim seniority, and that the seniority would be determined as per merit of the capability test conducted on 7/10/2007 and 14/11/2007. Accordingly, it is submitted that the petitioner was all along aware of how the seniority position would be determined, and therefore challenge to the said promotion order dated 18/12/2007 is vitiated by inordinate delay of 16 years in making the challenge. Full stop. In support of our submissions that delay in challenging of promotion, the delayed challenge delayed challenge to the seniority and promotion is not sustainable. And in this regard, she places reliance on the case of B.S. Bajwa, BAJWA, and others versus State of Punjab and others, 1998, bracket close, 2 SCC 523. Full stop. Next, further. The learned senior counsel for the
Your Lordship, one submission, Your Lordship. After they were promoted to the post of impositor, Your Lordship, the list of impositor came out, and wherein the respondent number 4 and 5 were placed above, and therefore the petitioner filed a complaint letter 7/7/2007, where I have categorically made a statement that we have not received this one, and even if assuming that we have received, Your Lordship, the petitioner has made this complaint only after 2 months. So, Your Lordship, the seniority list of impositor was only for 1 month, Your Lordship. Within 1 month, if they have not made any application, it has attained finality. Your Lordship, so that may also be recorded.
Before that, you write, it is also submitted that when the seniority list of impositors was issued
Yes, Your Lordship.
on
14 May 2007.
on 14/5/2007, which is that page?
Page 17, annexure 8 of my affidavit, Your Lordship.
Was issued.
That is on S on 31 to 2006.
Was issued on 14/5/2007, being seniority list of impositors as on 31/12/2006. It was clearly indicated that complaint, if any, should be submitted to the Director of Printing and Stationery, Nagaland, within 1 month
Yes, Your Lordship.
from the date of issue. And if no complaint was received within the specified period, the list would be treated as final.
Yes, Your Lordship.
Full stop. Accordingly, it is submitted that the complaint made on 7/7/2007 was beyond the time prescribed for making objections.
And moreover, we have not received, Your Lordship, this complaint.
It is also submitted
There is
that
no record.
specific stand has been taken by the respondent numbers 1, 2, and 3 in their affidavit that said complaint was never received in their department.
Yes,
Next, the learned senior counsel for the respondent number 4 has submitted that he supports the submission made by the learned advocate, and it was submitted that the respondent number 4 was appointed in the year 1999 as Inkman, which is the feeder post for impositor.
Not the Inkman, Lordship, impositor. My appointment was
impositor.
Yes, to the post of impositor.
You were appointed in 2005.
Yes.
Oh, acha, then mistake. The something that the respondent number 4 was appointed in the year 2005 as impositor.
Which is one post higher than the inkman,
Which is
the promotional post of the inkman.
which is the promotional post of inkman. And therefore, therefore it was incorrect. Projection of the case by the petitioner. As it was projected that the name of the respondent number 4 was not in the seniority list of inkmen, because by that time the petitioner was already posted in a higher position. It was also submitted that the appointment of the petitioner, respondent number 4 and respondent number 5, were made before the draft Nagaland government printing press within bracket technical bracket close service rules was rolled out in the year 2006-2007, and therefore as the rules, 2007 rules, which was adopted later on, did not provide any retrospective effect of the promotions which were already made prior to the coming into force of the Nagaland government printing press within bracket technical bracket service rules 2007. So accordingly, it is submitted that the position of the respondent number 4 cannot be disturbed. In view of his appointment to the post of imposter in the year 2005, which was before promotion was given to the petitioner. It was also submitted, it has also been submitted that the petitioner has not challenged any of the seniority lists, and that the order of promotion of the order of appointment of the petitioner as impositor and orders of promotion have also not been challenged, but the petitioner has challenged the consequential order of 18/12/2007 in this regard. It was submitted that as per the procedure adopted by the respondent authorities, the promotion was to be based on capability test, where the respondent number 4 as well as respondent number 5 scored higher than the petitioner, and therefore the constitutional order of 18/12/2007 is only to give effect to the position of the respondent numbers 4 and 5 in the eligibility test, for which the constitutional order What is the challenge to the consequential order dated 18/12/2007 would not be maintainable. Full stop. Full stop. It was also submitted that the belated challenge was not maintainable and the writ petition was liable to be dismissed on the ground of delay and laches alone.
Settled seniority position cannot be answered.
That's right. And it was also submitted that the settled seniority position ought not to be altered as the name of the respondent numbers 4 and 5 was all throughout placed before that of the petitioner. Next para. The learned counsel for respondent number 4 has also adopted the submissions made by the learned government advocate as well as learned senior counsel for the respondent number 4. And it is submitted that
Respondent number 5, Lord.
he's
4.
So that's what I'm saying. You have adopted his.
Yes, my lord.
Did I make a mistake?
It appears 4 was mentioned twice, my lord, that is why.
For respondent number 5. Okay. And it was submitted that the stand of the petitioner was to the effect that he was not aware of the promotion order dated 18/12/2007 was not at all acceptable.
As well as the first promotion order, lordship.
Which one?
My first promotion to the post of impositor.
Where is that?
Lordship, it's 3rd November 2005. That is prior to the promotion of the petitioner to the post of impositor.
No, where is the document?
My lord, it is at page 15 of my affidavit for the respondent number 5, and it should be.
Okay. Or that the petitioner was not aware of the initial promotion of the petitioner to the post of impositor.
Respondent number 5 to the.
Sorry, respondent 5 to the post of impositor by order dated 8/8/2016.
No, lordship. 3rd November 2005.
No, you're saying 15.
No, my lord.
Oh,
My
sorry.
promotion to the post of impositor is
Just
3rd
a moment,
November 2005.
Just a moment.
My lord.
I'm looking at a wrong document. Yes. Promotion of the respondent number 5 to the post of impositor.
Yes, my lord.
By order dated 3/11/2005 was not within the knowledge of the petitioner, cannot be, is not acceptable. On account of the fact that the promotion of the respondent number 5 to the post of impositor was prior to the date on which the petitioner got promoted.
Yes, lordship. 8/8/2006. That is the promotion of the
Which
petitioner.
happened on 8/8/2006.
My lord.
Moreover, it was submitted that in the promotion order Where is your second promotion order? Which page? This 2007 is page 20 of your affidavit. Page 20 of your affidavit.
Yes, Lordship.
88. Full stop. Full stop. By referring to the contents of the promotion order of the respondent number 4 and 5 to the post of printer
Yes, my lord.
dated 18/12/2007.
My lord.
It was submitted that in the said order, it was clearly mentioned that the promotion order would not confer him/her any right to claim seniority, and that the seniority would be determined as per the merit of the capability test conducted on 7/10/2007 and 14/11/2007. Accordingly, it is submitted that as the respondent number 5 was in receipt of a calling letter, which is annexed to the affidavit in opposition filed by respondent number 5 as Annexure D, it is inconceivable that the petitioner would not know about the call letter. Accordingly, it is submitted that not only the petitioner but the respondent numbers 4 and 5 participated in the capability test and scored, and the respondent numbers 4 and 5 scored higher than the petitioner, which qualified the respondent numbers 4 and 5 to hold seniority position than the to be reckoned as senior to that of the petitioner. And accordingly, it is submitted that the seniority position of the respondent number 5 should not be disturbed. And in support of his submissions, the learned counsel for the respondent number 5, on the issue of delay and laches, has cited the case of State of Uttaranchal and another versus Shiv Charan Singh Bhandari and others within bracket 2013, bracket close 12 SCC 179, and Shankara Cooperative Housing Society Limited, SHAN KERA, Shankara Cooperative Housing Society Limited versus M. Prabhakar, PRA BHA KER, and others within bracket 2011, bracket close 5 SCC 607. Next paragraph. It is noticed that the petitioner has challenged the order of promotion of the respondent numbers 4 and 5 dated (18 12 2007). By filing this writ petition, on 9/5/2023, which is more than 15 years after the order of promotion. Full stop. It is also noticed that the interstate seniority position between the respondent numbers 5, 4 and the petitioner. Respondent was 5, respondent number 4 and the petitioner. We are already notified in the seniority list published as on
Lordship,
1/11/2014, 27/2016, 17/7/2017, 1/4/2018, 1/4/2019, 1/4/2020, 1/4/2021, and 1/4/2023. Yes, you wanted to say something?
I just humbly pray that Lordship, this in the seniority list where my petitioner's date of promotion mistakenly they have.
Mistake will take care of later. First is the substantive challenge. First is the substantive. This is a what you call appendix, incidental issue.
On the face of report, Lordship, he was appointed, since I have, his promotion order is there, this can be rectified, Lordship.
No, we are not touched upon that till now.
Yes, yes, yes.
Correct. Now we are on the substantive challenge.
Yes, Lordship.
Therefore, we're not objecting to the interstate seniority position within the time allowed to make objections, all these seniority lists where the respondent numbers 4 and 5 were positioned above the petitioner have attained finality. Full stop. Therefore, the court is disinclined to accept the challenge in respect of the interstate seniority position of respondent numbers 4 and 5 in view of the inordinate delay of more than 15 years to approach this court. Full stop. Next, in this regard, we refer to the judgment of the division bench of this court. In the case of Pankaj Prakash, PANKAJ, Prakash PRAKSS, Decca versus State of Assam and others, within bracket 2021, 1 GLR 690, where this court, by placing reliance on the case of P.S. Sadasivaswamy, SADA, SIVA, SWAMI versus State of Tamil Nadu, within bracket 1975, bracket close 1 SCC 152, had held that the person aggrieved by non-promotion or promotion made belatedly should approach the court as early as possible. And it was held that the belated challenge would be liable to be dismissed on the ground of delay and laches. Stop. It was also held that mere non-consideration of representations filed by the aggrieved did not give rise to a new cause of action. Stop. In the present case in hand, the order of promotion was admittedly issued on 18/12/2007. Therefore, the challenge to this promotion order is after more than 15.5 years. The explanation by the learned counsel for the petitioner of the delay in approaching this court is not found convincing and acceptable in view of the fact that inter-se seniority lists were published by the authorities in the Printing and Stationery Department, Nagaland, from time to time, which reflected the seniority position of the petitioner to be below that of the respondent numbers 4 and 5. Full stop. Yes, but in this regard, we also find support from the judgment of the Supreme Court of India in the case of Shankara, SHANKARA, Cooperative Housing Society Limited within bracket Supra, wherein it was reiterated by the Supreme Court of India that delay and laches is one of the factors that requires to be borne in mind by the high courts when they exercise their discretionary power under Article 226 of the Constitution of India. By further holding that in appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on part of the applicant to assert his rights taken in conjunction with the lapse of time and other circumstances. The same principle is also laid down in the case of Shiv Charan, SHIV, Shiv Charan Singh Bhandari, cited at the bar. Stop. We do not intend to burden this order with repetitive replication of the same principles of law. So in that you also had, and BS Bajwa, BAJWA, within bracket Supra. Full stop. Next para. Therefore, as already indicated above, the court is disinclined to entertain this writ petition on the ground of delay and laches, as the seniority position of the respondent numbers 4 and 5 had been perfected by passage of time. And moreover, it is found that the position of the respondent numbers 4 and 5 was always higher that of the petitioner. An incidental issue has cropped up in this matter. From the materials available on record, it appears that in the interstate seniority list, which was prepared on 1/4/2023, which is a part of the writ petition, the date of first promotion of the petitioner is shown as 1/8/2007. So this is apparently an error because the order of promotion was passed on 8/8/2006. Stop. Normally, as a thumb rule, the court ought not to grant reliefs which are not otherwise prayed for. Full stop. The error that is kept in the seniority list with regard to the date recording of the date of first promotion the petitioner has not made a prayer for its rectification. Full stop. Nonetheless, having noted that the records reveal that the order of promotion of the petitioner as imposter was passed on 8/8/2006. The court is inclined to grant liberty to the petitioner to move the competent authorities for making rectification in the date of first promotion. Rectification only in respect of the date of first promotion to the post of impositor. And for no other purpose. Stop. It is provided that if such an application is made by the petitioner, the competent respondent authorities would look into the grounds of the petitioner and pass appropriate orders thereon. Yes. Yes, sir. Accordingly. We leave as indicated above, the petition stands dismissed.
At least he will be able to be at serial number 5 to go by the rectification. At least. At least.
Already run out for other matters.
Yes, time has run out.
Mention item number 45. Let this matter be on Tuesday, that is 12.
We are not passing orders. We'll ask the registry to get it listed. There's
Tuesday.
we are not saying that there's a reason which is different, quite different. I'll tell you the reason. I'll share you the reason. You see what has happened in the principal deed. There was a complaint in item numbers, let us say 5, 6 and 7 orders were passed, but in item number 8 a date was given. So the grievance was raised that why in 3 cases no orders were passed. And therefore, after that incident, what I'm requesting the lawyers is that you make a mention tomorrow morning, we'll pass orders for listing. But instead of passing an orders, because I'll be jumping queue and passing orders here and there, so it may lead to a discontent to one of the lawyers who will say that, well, I was watching from outside. I found orders passed in item 8, but my item was item 7, no orders were passed. So I'm sorry, you make a mention tomorrow morning.
My lord, I humbly pray that at least the petitioner, if this is rectified, he will be at rule number 5. So
No, that
at
I
least.
won't say.
No, Your Lordship, that will be a different subject matter, Your Lordship.
That
We
I
are
won't say.
relating only to respondent of 4 and 5.
You
Your
see,
Lordship. That cannot be
I have
allowed.
already, Madam, I understand. I've already said the court does not have power to pass orders on respect of prayers not made. Yet I am saying that in respect of this which has come to my notice, you made a representation for no other purpose. So that means if you want to have any other prayer, you'll have to file a next week petition. We can't do it in this order. Because in this, we have not given notice to the other side to respond. Altering of position is something we'll have to adjudicate. We can't do it.
Lordship.
This service rules, will just keep there. Tomorrow subject mentions will give dates, but we are not giving dates here. I think we told them. Left over. I'm sorry, but this incident happened to me, therefore I'm being very cautious. Because when complaints come, we don't have an answer.